recesses of the subcommittee at any time. We welcome everyone to this afternoon's hearing on building confidence in the Supreme Court through ethics and recusal reforms. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of today's hearing. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would like to also ask members to please mute your microphones when you are not speaking. This will prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. We are here today to consider a question that goes to the heart of our democracy. Should the United States Supreme Court, the highest court in our nation and one of the most powerful judicial bodies in the world, abide by a uniform and binding set of ethics rules? Ours has been described as a government of laws and not of men, and nowhere is that principle more essential than in the fair and even-handed administration of justice. This House is built on the rule of law. Its foundation is fairness, transparency, and accountability. But the lack of enforceable ethical standards for judicial officers is a crack in that foundation. It is a flaw that was first recognized nearly 50 years ago when the judges of the lower federal courts wrote and adopted an ethics code to bind themselves to better conduct. That code does not apply to the Supreme Court. The justices were unpersuaded by the actions of their judicial peers and did not see the need to act then, and they refuse to act now. The result is sadly predictable. A steady stream of revelations that justices have approached the line of acceptable behavior are in an ethical gray area, or seemingly more and more often have crossed the line entirely. The propensity to transgress is not limited to the justices appointed by presidents of one political party. And I'm afraid it's not a coincidence that recent polling has shown a marked decline in public confidence in the Supreme Court. Other events have made it disturbingly clear that without explicit enforceable rules, certain members of the High Court are going to keep trying to get away with more and more until they have gotten away with our whole republic. And I'm alarmed, for example, about unanswered questions about Justice Thomas's failure to recuse from a decision that we now know might have implicated the actions of his wife in her apparent efforts to overturn the 2020 election. This problem is much bigger than Clarence Thomas, however, but his is a case in point for why enacting enforceable ethics rules is long past due. Today we explore how to fix that crack in our foundation. If the justices of the Supreme Court will not act to safeguard their constitutional responsibilities as impartial judicial officers, then it's up to this body. It's Congress's responsibility to make laws governing the federal courts, which includes the Supreme Court. And there are several bills that would bring much needed improvements to the ethics and recusal practices of the Supreme Court justices. These include two bills I have been proud to lead in the House, the Supreme Court Ethics Act and the 21st Century Courts Act of 2022. Any meaningful ethics reform must include meaningful recusal reform. They go hand in hand and are crucial to ensuring that the decisions made by unelected officers who serve for life and who have the power to say what the law is are made fairly and without respect to persons or profits. That brings us to today's hearing and our distinguished panelists. I thank you in advance for your expertise and for the time you have devoted to these subjects and to this hearing, and I look forward to your testimony. And now I will recognize the ranking member for his statement.
Thank you, Mr. Chairman. Thank you for holding this important hearing, and I look forward to our witnesses. First, I would like to ask unanimous consent that we submit into the record an article penned yesterday from the Hill titled, House Panel to Explore Impeachment, Judicial Ethics in the Wake of Ginny Thomas's Text.
Without objection.
Thank you, Mr. Chairman. I'm going to comment only on the headline here today. A headline like that does no good to the court, and it does no good to, in fact, this body. The actions or beliefs or views of a spouse of a member of the court cannot, should not, and will not ever be grounds for impeachment of a judge. That, I think, goes without saying, and I am appalled that this kind of rumor and innuendo would even get into a headline, whether or not the context is appropriate. We have 9 justices of the Supreme Court. Those justices are well respected. They are humans, men and women. They are not perfect. They are mostly married or widowed. They, in fact, have lived long lives and served our country well. None of that is going to be doubted today. There is a question, and it is a legitimate question for us here in this body. The Supreme Court does not and cannot make laws. The executive branch is not empowered to make laws, although regulations sometimes carry the power of law. We are empowered with that. Therefore, the question of whether or not mandates under law shall be placed on the other 2 bodies will always be determined by this body. A voluntary standard by the executive branch can be changed by the executive branch. A voluntary standard by Article 3, the judicial branch, can be changed by them. Only a law passed by this body and signed by the President is binding on all of us until perpetuity or until changed by similar statute. That is what we will be considering today and in the days to come. I think we do so and must do so soberly because the separation of powers is real and it is for a valid reason. So as we listen to the witnesses and as we look at potential legislation, I know that all of us here on the dais will, in fact, do so knowing that we must measure carefully, measure again carefully, and make those cuts into the very fabric of our Constitution very sparingly. Having said that, I am afraid that the opening comments that I put in from the Hill newspaper could, in fact, be the subjects du jour, and they should not. The question of whether or not there should be additional legislation affecting the justices of the Supreme Court is one that I'm perfectly willing now and in the future to consider. But whether or not we are to pass a law or to recuse or to somehow admonish a justice of the Supreme Court because they had the audacity decades ago to marry somebody with an opinion is not something I want to hear or discuss or try today. And with that, Mr. Chairman, I yield back.
I'm now pleased to recognize the chairman of the full committee, the gentleman from New York, for his opening statement.
Let me start by assuring my friend, Mr. Issa, that as far as I know, nobody in this body wrote that headline. Thank you, Mr. Chairman, for holding today's important hearing. The Supreme Court is one of the nation's most vital institutions. Its duties are sacred: to administer justice and uphold the rule of law, and to do so independently and fairly. Now and as always, the court's fidelity to the principles of equal and impartial justice as well as the public's faith in the integrity of the judiciary, are foundational to maintaining the rule of law. Our federal judiciary is the envy of the world, and Congress has an obligation to ensure that this hard-earned reputation is maintained. Unfortunately, the reputation of the court has been undermined in recent years by the actions of the justices themselves across the ideological spectrum. We expect the justices of our nation's highest court to hold themselves to the highest standards of ethical conduct. But in fact, their conduct too often falls below the standards that lower court judges are required to follow. Public faith is weakened by every story about a justice being treated to a lavish junket, accepting an unreported gift, or failing to disclose an asset, appearing on stage on social media with a political candidate, attending $350 a head dinners hosted by dark money groups, or meeting behind closed doors with entities that have interests before the court. People are justifiably shocked when they learn that not only is there no code of conduct for the Supreme Court, but that the justices have steadfastly opposed the creation of one. Every member of Congress is subject to a code of conduct, as is every other federal judge. Article 1 and administrative law judges in the executive branch are subject to even more stringent ethics requirements, including a statutory prohibition on criminal conflicts of interest. Even more concerning are the justices' repeated failures to abide by the federal recusal statute, which does apply to them. Not a year seems to go by without another example in which a justice fails to recuse themselves despite having a financial connection to a party or having participated in a case before they became a justice. Clear grounds for recusal. A number of justices have suggested that they are subject to a less stringent recusal standard than every other federal judge, or even that the law might not apply to them in the same way as to other judges, or at all. In recent years, the recusal problem has grown much more serious. Last year, for example, Justice Barrett refused to recuse from a case involving a group that had spent more than $1 million advocating her appointment to the bench. 3 justices refused to recuse from a case involving the publisher who had given them 6- and 7-digit book deals. And of course, we know that Justice Thomas failed to recuse from at least one case involving the attempt to overturn the 2020 election, despite his wife's apparent direct and active involvement in that effort. The appearance of impropriety and disregard for the law can have devastating impacts on the public's trust in the integrity and independence of the judiciary. Our constitutional system suffers when it looks like the justices of the Supreme Court, the very people we entrust to maintain the rule of law, think that they themselves are above the law. Thus, we must remain vigilant against attempts to undermine the foundational ideals of impartiality and fairness upon which the public must rely. With the seriousness of this obligation in mind, I look forward to hearing from our distinguished panel of witnesses, and I yield back the balance of my time.
Thank you, and I'm pleased now to recognize the ranking member of the full committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Everyone can see through the Democrats' charade here today. This isn't about ethics or justice or the separation of powers. This is a partisan attack on the highest court in the land. The modern left has zero tolerance for people who don't adhere to their progressive ideology. Democrats control the executive branch, they control the bureaucracy, they control Congress, then they control this committee. Woke progressives control the media and academia. They are making inroads in big business, and they control most of big tech. They used to control all of big tech until a couple of days ago, and just the fact that one part of big tech may, in fact, now recognize free speech in the First Amendment, they're going crazy. But there's one place of power that the Democrats don't control, and they can't stand it. They can't stand the fact that they don't control the United States Supreme Court. Doesn't matter that the conservative justices on the Supreme Court were nominated and confirmed by the Senate for life terms in line with what our founders put in the U.S. Constitution. Democrats can't stand that conservative justices serve on the bench. And they're willing to destroy the Supreme Court itself to get their way. They're so desperate to take down our time-honored institutions in furtherance of their radical agenda that last year, senior members of this committee put out a bill to pack the Supreme Court. These Democrats, including the chairman and the chairman of this subcommittee, suddenly decided that despite 150 years of precedent, the magic number for the Supreme Court justices should now be 13. Just so happens that that's the exact number that would give Democrats a majority with the new appointments that would come from President Biden. The Democrat attacks on the integrity of the Supreme Court are not just limited to court packing. Prominent Democrats have said the Supreme Court is, quote, not well, and threatened to restructure the court if it doesn't heal itself, meaning decide cases the way Democrats want them decided. Senator Schumer called out Justice Gorsuch and Kavanaugh by name, telling them that they would, quote, will have to pay a price if they, quote, go forward with these awful decisions. Don't forget how Democrats treated Justice Barrett during her confirmation, questioning her faith, something that's mentioned in the First Amendment, first thing in the Constitution, questioning her faith and whether the, quote, dogma that lives around her or lives within her. And everyone remembers the public character assassination that Democrats committed against Justice Kavanaugh. These Democrats' attacks aren't new. They go back 30 years, back to when Senator Joe Biden chaired the Senate Judiciary Committee. Senator Biden's attacks were so egregious, they yielded a new verb, whole new word, borking, named after President Reagan's nominee to the Supreme Court in 1988, Judge Robert Bork. The dictionary defines borking as attacking or defeating unfairly through an organized campaign of harsh criticism or vilification. Think about that. Senator Biden's attacks were so bad, the dictionary had to create a new word to describe them. But the attacks were successful, and Judge Bork pulled his nomination. In 1991, Senator Biden tried it again on Justice Thomas. We are fortunate that the country is fortunate that Judge Thomas withstood these unfair attacks and is now Justice Thomas. But here we are, 30 years later, and the Democrats on this committee are trying to finish what Joe Biden started. And don't take my word for it. Read the chairman's own memo. The memo the chairman put out in advance of today's hearing has a whole section on previous attempts to impeach Supreme Court justices. Why? Why would he reference that? The only plausible explanation for this is that they are desperate to try to build the case to impeach one of the sitting justices in the next few months so they can try to remove them and replace them with another Biden appointee. This is as wrong as it gets. The American people expect better from us. There's a border crisis. There's a 41-year high inflation rate that is hitting everyone's pocket. There's a war in Ukraine, and Democrats are scheming in their ill-fated attempt to remove a life-tenured Supreme Court justice. This is not what we should be focusing on. Mr. Chairman, I yield back.
Thank you, Mr. Jordan. Without objection, all other opening statements will be included in the record. Before we introduce our panel of witnesses, without objection, I will enter the following written witness statements into the record. The first is a statement, Project on Government Oversight, or POGO, a nonpartisan independent organization devoted to exposing government waste, corruption, and abuse of power. POGO's statement discusses the longstanding need for a code of conduct at the Supreme Court, as well as other improvements in the recusal and disclosure process. The second statement is from the Leadership Conference on Civil and Human Rights, a coalition of over 230 national organizations committed to promoting and protecting civil rights in the United States. The Leadership Conference's statement also reinforces the need for decisive action on a Supreme Court code of ethics and strengthened recusal rules to ensure balanced, independent decision-making worthy of the public's confidence. The third is a statement for Alliance for Justice, a national organization representing over 130 public interest and civil rights groups. Alliance for Justice's statement voices support for the work of this subcommittee in holding this hearing and for the 21st Century Courts Act. I will, and without objection, I will so order inclusion in the record. I will now introduce the panel of our witnesses. Gabe Roth is the founder and executive director of Fix the Court, a nonprofit, nonpartisan organization that has worked to increase transparency and accountability across the federal courts, but especially for the Supreme Court, since 2014. Mr. Roth earned his undergraduate degree from Washington University in St. Louis and his master's degree from Northwestern University's Medill School of Journalism. Welcome, Mr. Roth. Donald K. Sherman is the Senior Vice President and Chief Counsel of Citizens for Responsibility and Ethics in Washington, or CREW. Mr. Sherman has a distinguished resume in ethics and oversight across the federal government, including time working in the White House, in both the House and Senate, and in a federal agency. Mr. Sherman graduated cum laude from Georgetown University and earned his JD from Georgetown University Law Center. Welcome, Mr. Sherman. Mark Paoletta is a partner in private practice representing clients in congressional hearings and investigations. Before entering private practice, Mr. Paoletta most recently served as general counsel for the Office of Management and Budget under the Trump administration and as counsel to former Vice President Mike Pence. Mr. Paoletta received his BA from Duquesne University and his JD from Georgetown University Law Center. Welcome, Mr. Paoletta. Professor Stephen Gillers is the Elihu, and I hope I pronounced that correct, Elihu? Elihu, okay, either one. He's the Elihu or Elihu Root Professor of Law at New York University School of Law. He is a nationally recognized expert on legal and judicial ethics and the author of several case books and articles, as well as a sought-after lecturer on the regulation of lawyers and judges. Professor Gillers earned his BA from City University of New York and his JD cum laude from New York University School of Law. Welcome, Professor Gillers. Before proceeding with testimony, I would like to remind all of our witnesses that you have a legal obligation to provide truthful testimony and answers to this subcommittee, and that any false statement you may make today may subject you to 18 U.S.C. Section 1001. Please note that each of your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. And when the light turns red, it means that your 5 minutes have expired. We will have 5-minute rounds of questions after the witnesses' testimonies. Mr. Roth, you may begin.
Thank you. Chairman Johnson, Ranking Member Issa, members of the subcommittee. Back in 2016, a Supreme Court justice failed to recuse in a major patent case despite owning $250,000 worth of shares in one party's parent company. That same year, a different justice spoke at a $500 per plate dinner with finance and oil executives. Another justice that year omitted from her financial disclosure report the fact that a public university paid for as many as 11 rooms for her in one of the state's fanciest hotels. In 2019, in the Supreme Court building, 2 justices met with the head of an organization that had submitted amicus briefs in 3 then unresolved cases. In 2020, a justice failed to recuse in a case concerning the constitutionality of a federal law that she likely worked on a legal strategy to defend in her previous job. And last year, a justice had dinner with a prominent politician and dozens of his friends, and then gave a speech with the politician at her side in which she said the Supreme Court, quote, is not comprised of a bunch of partisan hacks. These are just a handful of examples of Supreme Court justices flouting basic ethics rules in a handful of years that my organization, Fix the Court, has existed. I have dozens more in my written statement. And none of the justices just referenced was Clarence Thomas. When asked over the years how they confront questions of ethics that go beyond the recusal law, the justices say they look to precedent or scholarly articles or seek advice from their colleagues or law professors, but which precedents, which articles, which colleagues, and which professors? That there is not a single definitive source the justices use for guidance means that they'll be more likely to come up with different conclusions about their ethical obligations. This era of 9 justices operating, as has been said, like 9 independent law firms must end. It shouldn't be the case that half the justices accept flights on private planes paid for by big-time political benefactors when the rest stick to business or coach, or that 2 justices leave free trips off their annual financial disclosures while the rest are filing accurately, or that 3 justices trade individual stocks and are unable to participate in some cases because of it when the rest do not, and that 2 justices recuse in cases involving the work of a family member, but 2 justices do not when faced with similar circumstances. For these reasons and more, we need a formal written code of conduct for the Supreme Court of the United States. But a code is not a panacea. The rules governing recusal must themselves be expanded and modernized. If a justice's spouse, for example, was paid $250,000 at the time her employer filed an amicus brief on a major case, that justice shouldn't hear the case. If a justice received lavish gifts and was flown around the country by individuals and organizations funding merits and amicus briefs, there should be recusals in those cases. If a justice's wife's communications with a third party are subject of a congressional investigation and the Supreme Court is asked to rule on the validity of that investigation, the justice should recuse. The current recusal law says, among other things, that the judge or justice must recuse when, quote, his impartiality might reasonably be questioned. I'm a reasonable person, and I question Justice Thomas's impartiality in each of the examples I just mentioned, and sadly, in many more. But I'll grant the reasonable person standard could use some improvement. We need a law to ensure judges and justices take the proactive step of informing themselves of every personal interest and every financial interest of theirs and their spouses and their families that could be implemented by the outcome of a proceeding. They should recuse when those who financially back their confirmation appear as litigants. And when they're given a free trip, there should be a cooling off period afterwards. Take that trip, but then wait a few years before you participate in a case involving the sponsor. All the reforms I've discussed, a formal ethics code, a more exacting recusal standard, and a cooling off period are in the 21st Century Courts Act of 2022 that was introduced earlier this month. Now, why do we need this bill? Because time and again, we see that left to their own devices, the justices will do nothing to improve their policies and build a more modern, trustworthy institution. Despite all the ethics lapses I've mentioned, the justices have not lobbied, and they and the judiciary have lobbyists. The justices have not lobbied for any new laws, nor have they put any new accountability measures in place to my knowledge. Finally, this hearing is not the first attempt at fixing the judiciary's ethics lapses. The campaign to improve the recusal law and to implode an ethics code goes back 50 years. More recently, though, in 2018, the full Judiciary Committee unanimously passed a reform bill called the Judiciary Room Act. Led by Ranking Member Issa, the bill included a SCOTUS Code of Conduct, a requirement that the justices explain their recusal decisions, and a live streaming requirement. These elements were carried forward into the 21st Century Courts Act of 2020. They're included in the 21st Century Courts Act of 2022. And it's the spirit of bipartisanship that I pray carries the day, and that I hope that we can talk about more in our ensuing discussion. Thank you again for the opportunity to testify.
Thank you, Mr. Roth. And Mr. Sherman, you may begin.
Thank you. Chairman Johnson, Ranking Member Issa, and members of the subcommittee, thank you for the opportunity to testify before you today about the urgent need for Congress to ensure that federal judges meet the highest ethical standards. I am here representing Citizens for Responsibility and Ethics in Washington, a nonpartisan, nonprofit organization focused on ensuring the integrity of our government institutions. Today, there is a crisis of confidence in our federal judiciary. This crisis is the result of a number of overlapping failures, but chief among them is the judiciary's apparent inability to abide by the rules of ethical conduct their high office requires. In a 9-year period, more than 130 federal judges have presided over at least 650 cases in which they have a material financial interest in one of the parties. These conflicts have or will touch every congressional district in America. In addition, Supreme Court justices across the ideological spectrum have engaged in conduct that raises ethical or impartiality concerns. One of the more egregious examples in recent memory arises from a spousal conflict. Earlier this year, Justice Clarence Thomas failed to recuse from a case, Trump v. Thompson, where he was the lone dissent from the court's decision to reject former President Trump's attempt to block the release of documents requested by the January 6th committee. He did this despite his wife, Jenny Thomas's, active support of and communications with Trump administration officials about the subject of the committee's inquiry, the former president's efforts to overturn the 2020 election. By deciding to hear this case, Justice Thomas has undermined public trust in the court's impartiality. But the ethics issues facing the court are long-standing and not limited to one justice. The patchwork of rules and regulations that the federal judiciary developed to police itself has failed, and the Supreme Court's unwritten honor system is clearly broken. Public confidence in the third branch is at or near all-time lows, with 53% of Americans having an unfavorable view of the High Court. For an institution whose currency is credibility, this is an abject failure. Despite having the power of judicial review and enjoying life tenure, federal judges have substantially fewer ethical checks than their counterparts in the legislative and executive branches. We require even low-level executive branch employees to abide by a rigorous code of conduct, and we have numerous ways to hold them accountable, including by subjecting them to the criminal conflicts of interest statute. Yet our federal judges and justices are exempt from this provision. Not only do most government ethics rules not apply to federal judges at all levels, but the Supreme Court does not even have a code of conduct to provide clear and binding ethical guidance or a transparent process for recusals when conflicts do arise. It has become clear that the judiciary cannot or will not effectively regulate itself. It is now time for Congress to step in. We recommend 3 immediate actions that Congress can take to rebuild the federal judiciary's ethics regime. First, Congress needs to direct the Supreme Court to adopt a code of ethical conduct. Specifically, the code needs to include detailed standards to protect the court's impartiality and clear guidance regarding recusal, spousal conflicts, gifts, speeches, travel, financial conflicts, and other issues that I address in greater detail in my written testimony. Second, Congress should enact a blanket prohibition on all federal judges, their spouses, and their dependent children owning or trading any individual stocks or other similar financial instruments. Banning judges and their families from buying and owning individual stocks is the simplest way to address the financial conflicts that are undermining our judicial system. Many judges have claimed they are unfamiliar with their own assets or ethical obligations. Litigants often don't feel comfortable policing conflict concerns, but Congress can address this issue at scale. Third, Congress should apply the Federal Criminal Conflict of Interest Statute, 18 U.S.C. Section 208, to the entire federal judiciary. By expanding this key law, Congress would be adding a powerful tool to combat egregious ethical misconduct in the judiciary, while binding it to similar rules as the other branches, as Ranking Member Issa put it in October. In closing, it is important to note that the crisis of ethics in our government is the result of decades of benign neglect by leaders in all 3 branches of government, not the misconduct of one or even a few people. Ethics is not a partisan issue. The public can and should demand that federal judges are held to the highest ethical standards. As the public's representatives in Congress, the task is now yours to mandate reform. Though judges and justices interpret and sometimes strike down federal law, they are not above it. Thank you for the opportunity to testify, and I look forward to your questions.
Thank you, Mr. Sherman. Mr. Paoletta, you may now begin.
Chairman Johnson, Ranking Member Issa, and members of the subcommittee, thank you for this invitation to testify at this hearing titled Building Confidence in the Supreme Court Through Ethics and Recusal Reforms. Unfortunately, the title does not reflect what this hearing is about. If confidence in the court is lacking, it is not due to issues of ethics or recusals. Rather, the confidence in the court is undermined by the coordinated campaign by the corporate media and Democrats to smear conservative justices with the goal of delegitimizing the court. Why now? Because liberals fear that the court finally has a working conservative majority that may sweep away a number of longtime liberal landmark cases that cannot stand up to more rigorous constitutional scrutiny. And in this effort, Democrats and the media are trying to threaten, intimidate, destroy, and remove any of the justices who may constitute this new majority. If you think this is hyperbole, perhaps a brief reminder is in order. Democrat Senator Chuck Schumer stood on the steps of the Supreme Court in March 2020, directly threatening Justices Kavanaugh and Gorsuch as the court heard oral argument on an abortion case. He said, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions." Less than a year earlier, Democrat Senator Sheldon Whitehouse, the lead Senate sponsor of this proposed legislation, filed an amicus brief in the Second Amendment case pending before the Supreme Court, where he threatened the court that the court better drop the case or face the consequences. He wrote, "The Supreme Court is not well, and the people know it. Perhaps the court can heal itself before the public demands it can be restructured in order to reduce the influence of politics." And now, we are now in the middle of the latest attack in the 40-year war on Justice Clarence Thomas. this time an all-out assault on the justice and his wife, Ginny, for so-called ethical transgressions, such as Justice Thomas allegedly failing to recuse because of his wife's activities. It is a false and malicious attack on two good people. The left hates Justice Thomas because he is a black conservative who has never bowed to those who demand that he must think a certain way because of the color of his skin. Their racist attacks have repeatedly sought to portray Justice Thomas as dependent on white people, from Judge Larry Silverman on the D.C. Circuit to Justice Scalia on the
Chair,
Supreme
this is
Court.
completely out of order. I don't hate Justice Thomas. Nothing about his race.
Let
I
the
don't know why
witness
he's
finish his
just making these
testimony.
things.
This is not inappropriate at all. This is regular order.
The witness shall proceed.
And always his wife. It's despicable. Justice Thomas triggers the left, exposing their racism. But 30 years later, Justice Thomas is still standing strong, considered by many to be our greatest justice. But it appears that the left also really hates Ginny Thomas because she is an outspoken, unapologetic conservative woman. Justice Thomas has acted ethically and honorably at all times. To date, he has had no reason to recuse himself from any case because of his wife's opinions or activities. The new recusal standards being applied to Justice Thomas have no grounding in the law or in precedent. Judge Stephen Reinhart, a liberal icon from the Ninth Circuit, did not recuse from a case challenging a ban on same-sex marriages, even though his wife, who was the head of an ACLU chapter, had spoken out against the ban, and her organization had even joined 2 amicus briefs in the court below. Judge Reinhart wrote that his wife's, and this is quote, views are hers, not mine, and I do not in any way condition my opinions on the position she takes regarding any issues. Judge Reinhart concluded that, as Gabe said, a reasonable person would not believe he would be partial simply because of his wife or her organization's view. Judge Reinhart also determined that his wife had no interest in the outcome of this case beyond the interest of any American with a strong view concerning the social issues that confront this nation. Sound familiar? When Judge Reinhart voted exactly as his wife and the ACLU had advocated, nobody accused him of being a puppet of his wife. In fact, just Professor Stephen Gillers, co-panelist, filed a brief defending Judge Reinhart, writing, "A spouse's views and actions, however passionately held and discharged, are not imputed to her spouse. A contrary outcome would deem a judge's spouse unable to hold most any position of advocacy, creating what amounts to a marriage penalty." Justice Ruth Bader Ginsburg's husband, law firm, appeared several times before the Supreme Court, and Justice Ginsburg never recused herself. In fact, she voted in favor of Marty Ginsburg's colleague's client. Based on the law and precedent, Judge Reinhart and Justice Ginsburg properly did not recuse. But these and other examples in my written testimony prove that Justice Thomas is correct in not recusing from any case to date because of his wife's activity. More troubling, in 2016, Justice Ginsburg directly attacked candidate Donald Trump. She called him a faker, trashed him for not releasing his taxes, and opined that she feared living in America if Trump were elected. Talk about undermining the legitimacy of the court. She did not recuse from cases involving the Trump administration, including one where President Trump was challenging a subpoena to release his taxes. Of course she voted against President Trump. But despite Justice Ginsburg's dangerous foray into presidential politics prevent Donald Trump from being elected, no Democrat called for hearings or talked of impeaching her for these partisan attacks or her refusal to recuse from cases involving President Trump.
The gentleman was interrupted for his comments. He needs to finish.
There is nothing wrong with ethics and recusals at the Supreme Court. The justices are ethical and honorable public servants. Moreover, to support any reform legislation right now would be to validate this vicious attack on the Supreme Court. Thank you.
Thank you, Mr. Paoletta. Next, Professor Gillers, you may begin, sir.
Thank you, Mr. Chairman. Thank you for inviting me. When I talk about judicial ethics to continuing legal education classes, hundreds of lawyers, or in class, I always wind up saying there are 9 judicial officers in the whole country who are not governed by an ethics code. And this is counterintuitive because students or lawyers in the audience say, well, aren't those the judicial officers who should most be governed by an ethics code? How could this be true? And I explain how the Codes Committee of the Judicial Conference chooses not to adopt a code of conduct for the justices, and maybe it cannot. Maybe its position is correct. And someone will ask, well, what about Congress? And here we are. And I said, it's not so clear that Congress can do that. I think there are serious separation of powers questions over whether or not Congress can adopt an ethics code for the court, which is, like Congress, created by the Constitution. And anyway, it would achieve nothing, because you could legislate that the code for the lower federal court judges does apply to the justices, and then nothing will happen. And so the question comes back, well, what about the court? Can't the court adopt an ethics code for itself? And the answer is, of course it can. It adopted a rule governing when justices will recuse because of the presence of a lawyer relative in the picture of the case. Back in 1993, you can adopt an ethics code, and yet it hasn't. And that's unnecessary, and it seems to me there's ground here for nonpartisan agreement. Why hasn't it done it? Well, one reason is I think Chief Justice Roberts worries about in any way implying that the court is subordinate to Congress by adopting a code after being told by Congress to adopt a code. I understand that. Why can't he and the court adopt a code without that pressure? Well, they could say, we're doing it because we're doing it. We're not doing it because Congress wants us to do it. The route to getting a code is a separate issue from the content of the code or whether there should be a code. Some have said, well, it will create an increased risk of a 4-4 court. And that is wrong. The risk of a 4-4 court arises out of the recusal statute that does apply to the justices. If you look at the Code of Conduct for U.S. judges, I don't think there's another provision there that by itself could lead to recusal. There are things a justice might do that would violate another provision and warrant recusal under the statute. And so the danger of a 4-4 court is already with us because of a statute, not because of the code. And the final reason I hear is, well, who will police compliance? Who will police compliance with the code? And the answer is nobody. I think the answer has to be nobody. I disagree with the idea that the other 8 justices can police compliance with the recusal statute. The bill doesn't even anticipate that they will police compliance with the code. So one might ask, and people have asked, well, what is this all about then? Is it just about appearances? And the answer is yes, it is just about appearances. Appearances are really important in my world. We sometimes treat appearance issues as Emily Post for the legal profession. We like to talk about it, but it's not really meaty. It is very meaty. Appearances backed up by promises of compliance will achieve a great deal. And so, just as Section 455 is itself all about appearances, that's what it's about, appearances, not corruption, not bribery. We deal with that in another way. So too, a code with buy-in from the justices will help us persuade the American people who are surprised at the absence of one that it's an institution in which they can put their confidence.
Thank you, Professor Gillers. We will now proceed under the 5-minute rule with questions, and I will begin by recognizing myself for 5 minutes, and I will note the fact that in law school, I was always taught that lawyers and judges should avoid even a hint or an appearance of impropriety. And for judges, impartiality is on top of that. I'd like to also recognize the fact that there is immense popular support for a Supreme Court Code of Ethics. This has come from every quarter, ethics professors, members of Congress, analysts, and commentators on all sides of the political spectrum, from the progressive left to the avowed and lifelong conservatives. A recent poll found that 71% of voters favor a code of ethics, including 76% of Democrats and 63% of Republicans. Few policies are able to attract majorities that are so decisive. Mr. Roth, your organization has been working on this issue for nearly a decade. Have you ever seen so much high-profile public support for a Supreme Court code of ethics as you do now?
I think the support has actually been consistent over time. I've polled this question since I think 2012 when I ran a group called the Coalition for Court Transparency that was just singularly focused on broadcast, and then it became Fix the Court to focus on other issues. But yeah, it always polls in the 70s or 80s, always polls across partisan lines, and then, that's just a simple quantitative question. But when you do qualitative, it's kind of like what Professor Gillers said. Folks are surprised that the Supreme Court don't have a code of conduct. So once they realize that, whether in quantitative or qualitative, they're generally supportive regardless of their political valence.
Thank you. And Mr. Roth, it seems like the only individuals who do not support a code of ethics for the Supreme Court are apparently Mr. Paoletta and also the members of the Supreme Court itself. Are you aware of any other significant opposition to the code of conduct applying to to justices of the Supreme Court?
No, I'm not. And to me, what's interesting is that in 2019, Justice Kagan was testifying about her budget, and the Supreme Court's budget, and she was asked about a code of conduct, and she said Chief Justice Roberts is thinking about implementing one. So this has been on the justice's mind for a while now. There hasn't been any updates to that statement in 2019, but this is definitely something that has been on the justice's mind, and I think that after maybe this year or maybe some more years of congressional pressure, it'll happen.
Thank you. Professor Gillers, many of the current Supreme Court justices were judges of the lower courts where they were subject to more stringent ethical standards. Yet when they get to the high court, they start acting in ways they could not have acted when they were on the circuit or district courts. Why do you think that is? And is there any merit to the notion that justices act in ethically murky ways simply because they can?
Well, I hope not. Gabe would know more about what they do that is questionable. Why do people who are promoted from a circuit to the Supreme Court act differently, if they do act differently? Of course, there's no superior, right? When no one's watching and no one can tell you you did wrong, as the Supreme Court could tell every lower court judge they did wrong, you may not feel as conscientious about complying with the same rules that used to apply to you, but now do not.
Thank you. Mr. Sherman, does this make sense that judges get a promotion and as a result, they are subject to less oversight, less regulation, even as they make more and more consequential, wide-ranging decisions?
It certainly doesn't from an ethics standpoint. The justices on the Supreme Court, their decisions can be appealed, their recusal decisions can't be appealed, and yet they have not just a lower standard, but no standard, and certainly no transparency with respect to how they their recusal decisions. And it has created significant concerns about the court's impartiality.
Thank you. Mr. Paoletta, you gave a number of examples of ethical lapses perpetrated by Democratic-appointed justices of the Supreme Court, but yet you sit here today opposed to the U.S. Supreme Court being bound by a code of ethics itself. Can you explain why you make the case for a code of ethics, but then you don't want one?
The examples I used, Mr. Chairman, I actually said they didn't violate the recusal laws.
Well, let me ask this question. Is there any violations that a sitting Supreme Court justice can make that violate the code of ethics that is applicable to lower court judges?
again, I think Chief
In
Justice
other words,
Roberts.
if they do
yeah,
something
Chief
that
Justice
applies
I
to
guess.
lower court judges,
Yeah.
but they as Supreme Court justices are doing it, isn't it the same ethical lapse?
Right. I think my concern, Mr. Chairman, is that this is being done now, and Gabe may say it's been going on for a long time, but I find it curious that this is happening right now in the court, in the context of the sort of the controversy over Justice Thomas. And Chief Justice Roberts has said that they consult the Code of Ethics. As Professor Gillers says, it's not binding. The Code of Ethics is not a binding document. It's guidance, as it says it's very, so they already consult. Chief Justice Roberts has said that every justice consults the Code of Ethics. So,
But you don't disagree with the fact that there is a need for a code of conduct for Supreme Court justices. You don't disagree with that, do you?
so I think I think that the Supreme Court should answer that question in terms of, and I think Professor Gillers is right. I don't think it would
If they
be.
fail to answer that question as they have historically, does it mean that there should not be a code of ethics that applies to them?
I think what the Supreme Court is doing now in terms of the justices consulting a code of ethics and the code of ethics is working well enough, is working fine.
Okay, gotcha. Thank you. We will next go to the gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. Let's just be very blunt and clear about what's happening here today, as Mr. Paoletta just indicated. It's very clear that our Democrat colleagues and many Democrats across the country are continuing to bully and intimidate the Supreme Court now that there's a conservative majority. I mean, that's clear. Judicial ethics is obviously a subject worthy of our examination, but Democrats' goal in this hearing is clearly to attack Justice Clarence Thomas. We've heard it over and over. It was occasioned by the recent news events. And Democrat attacks on Justice Thomas and his wife Jenny are overtly and overtly partisan and clearly wrong. And if anybody thinks that the charge that Democrats are attempting to bully and intimidate the court is hyperbole, just Google the video of the comments that Mr. Paoletta mentioned. Just one instance, March 2020, Senator Chuck Schumer. I'm gonna say it again, he threatened conservative justices on the highest court in this country, on the steps of the Supreme Court, while the court was hearing oral arguments in the June Medical Services case, the Louisiana abortion case, which ironically, I was the trial court litigator on that case before I got to Congress years ago. And he said this is what he said, quote, this is Chuck Schumer, okay, leading Democrat in the US Senate. He says, I wanna tell you, Gorsuch, I wanna tell you, Kavanaugh, you've released the whirlwind. You will pay the price. You won't know what hits you if you go forward with these awful decisions. It's staggering that a member of the US Senate, a leader of the US Senate would say such a thing about our third branch and the justices who serve there. Mr. Paoletta, while Democrats continue their public smear campaigns against conservative justices, they obviously fail to call out the egregious behavior of liberals, judges, justices, and politicians. Isn't it true that during Justice Ginsburg's tenure on the court, her own daughter drafted an amicus brief in a case before the court, and the petitioners in the case cited that brief numerous times?
That's correct.
Did she recuse herself from that matter?
She did not.
In 2016, Justice Ginsburg made public comments criticizing then presidential candidate Donald J. Trump, calling him a faker and questioning why candidate Trump had yet to overturn his tax returns. Do you know whether Justice Ginsburg recused herself from matters involving the Trump administration or President Trump's tax returns?
She did not.
My Democrat colleagues regularly like to complain about conservative judges and justices speaking at Federalist Society events. This is a drumbeat that we hear all the time, as if somehow they're engaging in grand conspiratorial discussions. But isn't it true that Justice Sotomayor, for example, is scheduled to appear at the American Constitution Society, which is the left's version of the Federalist Society, at their national convention this summer?
Correct.
I haven't heard any public outcry about that. Maybe we should start a petition and ask her not to do that. Despite these and countless other examples, Democrats would like one set of standards to apply to conservative justices, like Justice Thomas, and not liberal justices and judges. Mr. Paoletta, why do you think congressional Democrats only train their ire on the conservative judges appointed by Republican presidents?
Again, I think this is a concerted effort to undermine the legitimacy of the court right now with this conservative working majority. With respect to the Justice Ginsburg example with her daughter, in fact, a court watcher noticed and said that in reviewing the decision that Justice Ginsburg, perhaps influenced by her daughter's opinion, law review article, came out a copyright hawk, which looked like she was influenced by her daughter's opinion or article. So, you know, I think it's just an effort to delegitimize the court.
And you are probably aware, I know members of this subcommittee are, that H.R. 2584, the Judiciary Act, it's co-authored by Representatives Nadler and Chairman Hank Johnson, would add 4 justices to the court to give liberals a 7-6 majority. Shows their great concern about that. And then the Judicial Conference's most recent recommendation asked Congress to create 77 new district court judgeships. And our chairman of this subcommittee, Chairman Hank Johnson, introduced a bill to create 203. So it seems apparent there's a long list of actions and activities that they've taken and statements they've made. I'm running out of time. I don't have the time to list it all here, but it is quite clear that there is a grave concern on their part that we do have a conservative majority this time around, and they're taking these desperate attempts to change the rules, change the count of judges, change the court itself, because they're so deeply concerned about that. I just think it's just readily apparent. I think it needs to be pointed out because it's so obvious. I'm grateful for the clarity and conviction of your testimony. I appreciate all of our witnesses be here, and I yield back.
Can I just add?
Sure, I have time.
Yeah, I mean, the talk from a lot of advocates that the conservatives are bought and paid for by dark money is really just so offensive, and it shows up in some of the testimony here. But the idea, and Senator Whitehouse is the one who pushes this the most, which is that these 5 or 6 justices are bought and paid for by dark money on the conservative side is absolutely offensive to me.
Unbelievable, unbelievable. Thank you, I yield back.
We will now hear from the gentleman from New York for 5 minutes.
Thank you, Mr. Chairman. Professor Gillers, whom I have admired for many years, and not just because he teaches at NYU in my district, seems to think that anything we may do about a code of ethics for the Supreme Court is unconstitutional and unenforceable. Would you comment on that, Mr. Sherman?
Thank you for the question, Congressman. Well, as another witness who appeared before the committee in October, Professor Jamal Green at Columbia testified, Congress has broad constitutional authority to provide that ethics rules apply to the Supreme Court justices. I think there are some questions about enforcement, which I agree with Professor Gillers, need to be explored, but I think there are mechanisms that can be put in place to address any constitutionality concerns. And there are a number of options to do that for creative thinkers in Congress and at the court.
Well, thank you. I'd like to talk about justices' speaking engagements. These can create conflicts or the appearance of conflicts in a number of ways. The first has to do with closed-door remarks made to audiences advancing a particular political agenda. Mr. Sherman, do you think Supreme Court justices should have to give their public speeches in public?
Yes, I think they should have to give their public speeches in public. They need to be mindful of the appearance and impartiality concerns that can arise from giving speeches to folks behind closed doors, and can publicly post that information. But most importantly, I think it highlights the need for a clear standard that is publicly disclosed so that everyone knows what it is and that the justices have clarity and consistency across their behavior.
Thank you. Mr. Roth, another concern with speeches made by Supreme Court justices is that they are often accompanied by lavish gifts of travel and accommodations. Often these gifts of travel and accommodations go unreported because the judiciary has interpreted the Ethics in Government Act as requiring very narrow disclosures. Can you tell us more about the kinds of gifts that justices typically receive as part of their speaking engagements and why that can create an appearance of impropriety?
Sure. So a few years ago, my organization sent some public records requests to public universities to try to figure out what type of perks they were getting. And we found that, for example, Justice Thomas was flown on a private plane to teach at the University of Florida. Justice Alito was offered a private plane to give a speech at the opening of University of South Carolina, but a hurricane canceled that flight, and he just ended up taking business class. Justice Sotomayor, when she gave the commencement address in Rhode Island in 2016, was offered 11 hotel rooms at the state's fanciest hotel for her security detail, and some family friends. So this is a problem across the board, and I think that part of the 21st Century Courts Act says that the justices should follow the travel rules that members of Congress do, and they have to report within 30 days of coming back from a trip who paid for the trip and how much it cost.
Thank you, Mr. Roth. Again, a related issue to justice speeches is the kinds of conferences that justices and many lower court judges are invited to attend. These conferences are frequently organized by groups pushing an ideological or industry-biased agenda, and they're often used to introduce new, previously unknown or fringe legal theories into the mainstream and into the tops of judges' minds. There's a name for this kind of behavior: lobbying. Yet the justices of the Supreme Court do not have to disclose these attempts to influence them, should they?
Absolutely. I think there's a few things. One, a lot of these speeches sometimes, well, okay, so to go back to what Don said, the Supreme Court justices, there is a site on supremecourt.gov where justices can publicize what they've said to whom and when, and that page hasn't been updated for like 5 years, and the last people to do it, I think, were Stevens and Ginsburg. So yes, what they're saying to whom and when should be publicly available. Certain justices live stream their events. Barrett recently live streamed an event. Thomas recently did, but Alito didn't. Gorsuch didn't. It's just, again, every justice should be required to follow the same set of rules, and the fact that they're not just makes the appearance of impropriety. It makes us think that they're doing something behind closed doors.
Thank you, Mr. Sherman. Your written testimony mentioned the draft advisory opinion number 117, which would have prohibited lower court judges from being members of judicial advocacy groups like the Federalist Society and the American Constitution Society. That opinion would not have applied to the Supreme Court, but should the Supreme Court adopt a code of conduct that includes a similar prohibition on membership in these kinds of groups? And when justices are members of outside political groups seeking to influence the federal judiciary and the interpretation of federal law, does this create the impression that justices are not deciding cases impartially or on their merits?
Absolutely.
Thank you.
Gentleman's time has expired. We'll now go to the gentleman from California, Mr. Issa.
Thank you, Mr. Chairman. Mr. Paoletta, gentleman next to you, Mr. Sherman, in his statement cited that the prohibition or the recusal standard should include both spouses and children as to their stocks, bonds, ownership, and conflicts. First of all, is that reasonably possible? I have a 42-year-old son. Should I have to recuse myself because my son has an interest in some company using the same standard that is currently the congressional standard or the executive standard?
Congressman, thanks for the question. I testified on this topic with respect to Congress 2 weeks ago, and I think the standard should be the same, that members of the federal judiciary should be banned from owning and trading individual stocks and include their dependent children and their spouses, not their adult children.
Okay, so the president flying Hunter Biden on his aircraft to take him to Eastern Europe or to China, where he did business and made millions of dollars as he got off of Air Force Two with the president, would that or wouldn't that be a conflict the way you're looking at it, since Hunter Biden was only dependent on drugs, not on his father?
So I'm not familiar with the example that you're providing, but again, I would note, as I said, the conflict concern is most significant, and I think the focus of the prohibition should be on dependent children and spouses, in addition to, obviously, the principals.
Okay, Mr. Paoletta, the concept that you would be recused when there's only 9 justices because of anything that your spouse said, did, or had in the way of ownership. You know, on lower courts, if a judge is pushed off or recused, either from a 3-judge panel or from being the actual presiding judge, a replacement judge is brought in. Is there any provision for the court to do that, for the high court?
There's not, Congressman. And the court addressed this in 1993 by issuing a statement of recusal policy where they interpret. So again, this is the Supreme Court interpreting Section 455, where they say that we're not going to recuse ourselves from family members who are involved with cases below the court. So they could be involved at the district court level, And at the Court of Appeals level, so long as they're not the lead attorney, right, and so long as not
In other words, don't appear in front of me.
right, don't appear. So if you take those examples and apply it to the Thomas situation, right, or even with respect to the Reinhardt situation, they're at the lower court. They're not before the judge. So, and then with respect to kind of statements that Ginny Thomas has made, they have not, this fits squarely within the statement of recusal policy that the Supreme Court has adopted, which is implementing 455. So
It's a well-understood standard that wouldn't apply. In the Reinhardt case,
yeah.
this is an adjudicated case. This is a well-thought-out case that squarely would seem to say that the accusations about Justice Thomas's recusal requirement because of his wife is in no way even as close as it was with Reinhardt, wouldn't you say?
Yes, she was actually commenting on a specific case that was pending, and her organization filed two amicus briefs that went up to her husband. So Ginny Thomas commenting on, again, one of the things I object to is the statements by some critics that because Ginny Thomas, Michael Tomasky from the New Republic, as I have in my written statement, he said that because Ginny Thomas said that Obamacare was a disaster, that Justice Thomas has to recuse. That's absolutely absurd. But he's calling for his impeachment because he didn't recuse from a case where she made that sort of comment. And if you apply that sort of logic to what happened in the Reinhardt case, and again, I never thought I'd read an opinion from Professor Gillers as much in terms of his filing and defending Reinhardt on that. They're not even anywhere close to what happened in the Reinhardt case, or, as I've talked about in my written testimony, Judge Pillard on the D.C. Circuit, where her husband, who's the legal director of the ACLU, specifically reviewed the Trump v. Mazar case, and that went up to her on an en banc appeal.
In the remaining time, Mr. Gillers, since you've been cited a couple of times, would you like to comment on why you seem to be on two different sides of this issue?
Thank you. I don't believe that Justice Thomas would have to recuse from the Obamacare case because his wife vocally, publicly, and emphatically and repeatedly objected to Obamacare, because we do not impute her public position to her husband for purposes of recusal. It's the same thing that happened in the Reinhardt case. It's the same thing with David Cole and Nina Pillard. End of story.
Thank you. Thank you, Mr. Chairman.
Thank you. Gentleman from California, Mr. Liu, is now recognized.
Thank you, Chairman Johnson, for holding this important hearing. The United States Supreme Court does not have an army. The court cannot raise money. The court cannot pass laws. The only power the Supreme Court has is from the belief of the American people that it interprets the laws in a fair and impartial manner. Unfortunately, as a result of some of the conduct of some justices, they have acted more like partisan hacks than judges. Let's just go through some of these examples. Last year, Justice Amy Barrett attended a dinner with the Republican leader of the Senate and a dozen of his friends, and then gave a speech. This year, Justice Gorsuch went to an event that was closed to the press with other people, including Republican Governor Ron DeSantis and former Republican Vice President Mike Pence. Justice Alito, in 2019, attended a Madison dinner with other politicians and Republican donors. This year, Justice Thomas, in the United States Supreme Court alcove, took a picture with Republican candidate Herschel Walker for Senate, and the Walker campaign then sent that picture out. So, Mr. Sherman, what do you think is the damage to the court's reputation if people perceive it as a partisan institution instead of an impartial institution?
Well, I think as Mr. Nadler said, the court's currency is its credibility, and impartiality is the reason, or the perception of impartiality is what gives the court its authority. And I think if the American people begin to believe that the federal courts are not impartial, not only does it damage our concept and conception of democracy, but if people feel like they cannot go to the judicial branch for relief, my fear is that they will rely on extrajudicial means to resolve disputes. This is not just simply some judges who are taking pictures with politicians or not recusing from cases where there's a financial interest. These are fissures that will undermine the entire foundation of the court. The highest court in the land needs to have the highest ethical standards. Right now, they have none.
Thank you. And the American public now knows this. According to Gallup, that has been tracking Supreme Court ratings, a little over 6 months ago, here's an article that says, approval of U.S. Supreme Court down to 40%, a new low. This February, Axios reported Supreme Court approval rating tanks. But it's not even just partisan behavior. We have just straight up unethical behavior. So, Mr. Roth, you have compiled this list of ethical lapses by Supreme Court justices, and there are a number of them, but man, oh man, you look at Justice Clarence Thomas, his list is like 2 to 3 times as long as anybody else. So let's just go through some of this. Justice Thomas accepted private plane rides and gifts, including a Bible once owned by Frederick Douglass, valued at $19,000 from financier Harlan Crow. Crow also donated $500,000 to help Thomas's wife, Jenny Thomas, establish Liberty Consulting. Is that appropriate, Mr. Roth?
No, it's not, and it's unique, I think, to Justice Thomas. There's not a similar situation with any of the other justices, according to what you cited.
Now let's talk about dark money. Justice Clarence Thomas attended a Coke Industries retreat in Palm Springs, California, at a time when Coke was bankrolling several litigants with cases before the Supreme Court. This is even the appearance of dark money. This is Justice Thomas going into the eye of the hurricane of dark money. Mr. Roth, was that appropriate?
It's not appropriate, no.
Okay. Now, I don't care how crazy Justice Thomas's wife is or the crazy things she engages in, but I do care if he attempts to cover up her crazy actions related to the January 6th insurrection, and that is the problem. There is a January 6th congressional committee investigating this, a bipartisan committee. The Department of Justice has indicted people because of the January 6th attack on our Capitol. Jenny Thomas has been sending text messages regarding January 6th to the Chief of Staff of the White House. And then when Justice Thomas votes no on a case about disclosure of documents related to January 6th, that is a problem. He should have recused himself. And let me just end by saying the entire congressional branch, we have a code of ethics, we have an ethics committee. Executive branch has a code of ethics. Only the 9 justices do not. They need one. I yield back.
The gentleman from Texas, Mr. Goldman, is now recognized. 5 minutes.
Thank you. I know one of the canons for federal judges, and of course it's been discussed that it is probably unconstitutional for another branch or even lower judges to prepare canons of ethics that bind the Supreme Court. But canon number 4 says in part, a judge should not participate in extrajudicial activities that reflect adversely on the judge's impartiality. Mr. Paoletta, can you think of judges on the Supreme Court that have given indications, in addition to just the ones you mentioned in your testimony, of where they're going to go on rulings?
I think I have a little bit more faith in justices in terms of speaking before groups and not it affecting their decision-making. But I do point out in my written testimony that Justice Ginsburg never recused from a case from the National Organization of Women when they filed amicus briefs, despite her serving on the board of NOW in the 1970s. She donated an autographed copy of her VMI opinion to be auctioned off for a fundraiser for the NOW PAC. She spoke in 2004 at a lecture named after her for the now legal defense fund. And 2 weeks before that lecture, she voted in favor of a position advocated by the now legal defense fund in an amicus brief. So we can talk about the justices, but Justice Ginsburg never seems to come up in terms of the concerns about a justice doing political things or entering the political fray. As I said in my oral testimony, she literally entered the 2016 presidential campaign to stop Donald Trump from being president of the United States. That was her intended purpose. I think that's unprecedented in modern times.
I do recall that. And it is interesting, though, if you're a liberal justice on the Supreme Court and family members even participate in a brief before the court, well, you're fine. That's okay. We don't see that as any problem. But let me tell you, when you come in here and you talk about the credibility to attack Justice Thomas, and he is the only name that you mention, you have credibility problems. That's just the way it is. And let me also tell you, one of the most far-reaching opinions ever issued, in my opinion, by the Supreme Court was the Obergefell case that really forced on states that they must recognize same-sex marriage. Well, here's an article that talks about, and of course, argument in the case, April 28, 2015, was decided June 26, 2015. In May, Justice Ginsburg presided over a same-sex wedding in advance of the Supreme Court's decision. And in fact, when she pronounced the marriage, as the New York Times reported, not that we can trust them, but that she said, quote, with a sly look and special emphasis on the word Constitution, Justice Ginsburg said that she was pronouncing the two men married by the powers vested in her by the Constitution of the United States, unquote. It would seem to me that that was giving an indication, to quote the Canon 4, that of what the judge's feelings were on that case. And not one of you ever brought that up. That didn't bother anybody at all, even though it was such a far-reaching case. Justice Thomas knows what all of my very conservative, dear black friends know is nobody is treated more brutally in this country than a conservative black. And it's just like Justice Thomas said at his hearing. He was the victim of a high-tech lynching, and I would submit anyone that continues that abuse is further contributing. No, is further contributing to the same high-tech lynching. Yes, sir. I've got 7 seconds.
I just want, can I just clarify on this? This photo that's been mentioned a couple of times, I think it's in Gabe's list and all that. That photo that Justice Thomas appeared in with Herschel Walker was part of a group that he hosts at the Supreme Court, the Horatio Alger Association, of which he's a member, and of which Herschel Walker was just inducted, okay? It's an incredible organization with people across the political spectrum, of people who have overcome difficult circumstances, and they have a reception up at the Supreme Court. That's why he was taking a photo with Herschel Walker. It wasn't related to his
Herschel's
campaign.
a conservative, too. That's
Gentleman's time has expired. Now go to the gentleman from New York, Mr. Jeffries, for 5 minutes.
I thank the distinguished chair for your leadership, for convening this hearing. I thank all the witnesses, particularly Professor Gillers from my alma mater, NYU. Great to see you, and thank you for your presence here today. You know, my distinguished colleague from Texas just made the observation that Justice Thomas has been subjected to a high-tech lynching. It's quite extraordinary. And I believe, Mr. Paoletta, you've echoed a similar sentiment. I think your quote is, many on the left hate Justice Thomas because he is a black conservative who has never bowed to those who demand that he must think a certain way because of the color of his skin. What evidence do you have to support that incendiary charge?
When Sherman Benny Thompson calls him an Uncle Tom, because of his views on voter ID and affirmative action, when in fact more Black Americans support voter ID and with respect to affirmative action in college education, they're 62% opposed to it. So that is the most vile, disgusting thing you can say. And so yes, that's the evidence that I just gave you.
Reclaiming my time.
Yes.
There are a lot of vile, disgusting things that can be
Well, you just
said.
asked me for an example.
The notion that is, right, when some members on this side of the aisle and others have been called the N-word throughout different points of our life, belies the point that you have a particular bias. And it's an overstatement, which is not surprising when you look at the balance of your testimony. And if Chairman Benny Thompson has an observation to make, he's entitled to free speech. You apparently believe that Jenny Thomas, regardless of how many conflicts she has, is entitled to her own political opinions as well.
Can I give you another example?
No. Let me go to Professor Sherman and Mr. Roth, because this notion that Clarence Thomas is being singled out because he's a Black conservative, whatever that means, I think is belied by the fact that if you look at example after example, there seems to be troubling instances where he's making rulings in cases where his wife has a clear interest. I think in 2010, Jenny Thomas was the president and CEO of a dark money group called Liberty Central, stood to benefit from the outcome of the Citizens United decision. Mr. Roth, did Justice Thomas recuse himself from that case?
He did not.
Okay, that same group apparently paid Jenny Thomas $120,000 per year to actively lobby for the repeal of the Affordable Care Act. She was paid to try to bring about an outcome that was at issue in the National Federation of Independent Business versus Sebelius case. Mr. Roth, did Justice Thomas recuse himself from that case?
He did not, nor any of the other Obamacare cases.
In 2017, a group called the Center for Security Policy filed an amicus brief with the Supreme Court to support Trump's outrageous Muslim ban. Now, at the same time that amicus brief was filed, Jenny Thomas was being paid roughly $200,000 in consulting fees, according to IRS documents. Did Justice Thomas recuse himself from that case, Trump v. Hawaii?
He did not.
And then we've got the most recent example in a parade of horribles. It's interesting how my friends want to focus on Justice Ruth Bader Ginsburg, may she rest in peace. We got someone who's actually on the Supreme Court right now making decisions actively in cases where his wife has clear interests. Text messages reveal that Jenny Thomas was in active communication with the former White House Chief of Staff as it relates to perpetuating the big lie that Donald Trump somehow won the 2020 election, notwithstanding no evidence to suggest that in fact is true, and was involved in trying to push this forward. There's a case that takes place to try to produce those communications with Mark Meadows in the White House. And Justice Thomas is the only justice who decides that those documents should not be released. His wife's documents should not be released. Every other conservative justice in that case voted that those documents should be released. Do you think it might have been appropriate for Justice Thomas to recuse himself in that particular case?
Yes, his wife's interests were clearly implicated in that case.
Thank you, sir. Thank you for your testimony. I yield back the balance of my time.
Thank you. The gentleman from Florida is now recognized for 5 minutes, Mr. Gates.
Well, thank you, Mr. Chairman. It's quite something to hear my colleagues reflect that we shouldn't be able to observe conditions regarding Justice Ginsburg because she's left the court when they impeached a president who had already left the Oval Office. Mr. Paoletta, I wanted to give you an opportunity to extend your remarks regarding instances of racism that you believe Justice Thomas encountered as a consequence of of his skin color and his politics?
Sure, I think it's I have it in my written testimony too. It's this narrative that Justice Thomas is a lackey of Justice Scalia, of Judge Silberman when he was on the court, and the writing is all that he is incapable of being a justice, which is so belied by the facts. He's the most independent thinking justice, probably in history. He writes the most opinions per year of any justice. When the documents came out from Justice Blackmun, it showed that from his very first conference, he voted in dissent on his own and brought 3 or 4 justices over to him in the first case that they dealt with. And time and time again.
I'm sorry, is it an attempt to try to invoke a racist trope that black people are not as intelligent and thus are more persuadable?
Yes, and if you look at the current attacks on Justice Thomas, where Philip Bump writes that Mayor's piece dances around the question of how much influence Ginny Thomas has over her husband. The one person Clarence really listens to is Virginia. Michael Kranish's piece in the Washington Post quotes Democratic operative Mark Fabiani wondering aloud whether there is a single opinion that Justice Thomas has ever written that is inconsistent with his wife's far-right wing views. So he is following her. And it's just the most offensive thing in the world when you read a lot of court watchers who are serious about the court, they know that Justice Thomas is the leader of the originalist wing and brought Justice Scalia over to his side, probably more than Justice Scalia ever brought Justice Thomas over to his views on the areas where they disagreed.
When someone calls a black person an Uncle Tom, is that a racist attack?
Yeah, I think it is. I think it's a disgusting attack.
Do any of the other panelists dispute that testimony? Does anyone think that there's a non-racist way to call a black person an Uncle Tom? How should we think about the fact that the chairman of the January 6th committee, the chairman of the Homeland Security Committee, used what all of you concede is a racist attack against Justice Thomas?
Congressman Jeffries asked me for an example. I gave it to him. I'll let others just address it, but I just think it is indicative of the hatred that is directed towards Justice Thomas for his views, which in fact, if you look, I wrote an article on this of comparing Justice Jackson and Justice Thomas's views on a number of issues in terms of polling, and by and large, Black Americans rank and file agree, I think, on abortion, on guns, on voter ID, on across the board. And yet somehow he's portrayed as being an Uncle Tom or a sellout or whatever the disgusting characterizations are. And it's just this continual attack on Justice Thomas. And thank God he's had the backbone to never bend in the face of these attacks. And I think this hearing today is a continuation of that. Everyone's focused on Justice Thomas. And let me just address the January 6th case, where that case has to do with executive privilege over internal White House documents between the president and his closest advisors. They have nothing whatsoever to do with Ginny Thomas's communications with Mark Meadows. Those wouldn't be covered by executive privilege. So Justice Thomas was voting on a document, on documents that were not at all related to his wife. So, that's why I say up until this point, there could be cases down in the future, as every justice does. When the case comes before the court and they look at the litigants, they look at the parties, they look at what's at issue, they decide whether they recuse.
So that I understand your testimony, you believe it's a racist trope to designate Justice Thomas as like uniquely unintelligent or persuadable. You believe it's a racist trope to call him an Uncle Tom, and you believe that this committee is a continuation of that effort.
Yes, and I believe it started when he first came to town in 1980. On joining the Merrigan administration.
Let's hope it ends. I yield back.
We now turn to the gentleman from Arizona, Mr. Stanton, for 5 minutes.
Thank you very much, Mr. Chair. I thank you to the esteemed panel of witnesses who have joined us here today. as we draft and consider legislation focused on a code of ethics for the Supreme Court. I hope you know that your knowledge, testimony, and contributions to this process are vital to this committee's work, and we do greatly appreciate your time. Throughout this Congress, this subcommittee has methodically addressed many longstanding concerns with the federal bench, from the diversity of judges to recusals for conflict of interest and workplace misconduct in the judiciary. And we've taken on some pretty serious issues to modernize the court system. But it's clear today that the American people do share a crisis of confidence in the Supreme Court. Recent polling suggests that public approval of the Supreme Court is at an all-time low, and only about half of Americans say that they have at least a fair amount of trust in the United States Supreme Court. Mr. Roth, in your opinion, should Congress and the justices act now to do what they can to restore faith in the institution of the court?
I mean, I think we're past the time of the justices acting. They've known about these issues for years, and they've done nothing time and again when they've been faced, whether when Jim Sensenbrenner was chair, or Bob Goodlatte was chair, or Lamar Smith was chair. They haven't done anything. So it's really, as we've learned recently with the Courthouse Ethics and Transparency Bill that Congressman Ross and Issa wrote that just passed the House final passage today, it's really up to Congress to take that step and draft the legislation to modernize the judiciary, because left to its own devices, the judiciary is not going to fix itself.
I agree with that sentiment completely. Mr. Sherman, ethics codes are common sense, in part because they are so commonplace across so many professions. Can you tell us about other ethics rules applicable to other government employees, for example, in the executive branch?
Absolutely. So executive branch employees, even low-level ones, have lots of requirements and accountability, including the Conflicts of Interest Statute, 18 U.S.C. 208, criminal statute which bars them from engaging in matters where they can have an impact on their or their family's financial holdings. Both Congress and the federal judiciary are exempt from that provision, though I would note that the House and Senate have a code of ethical conduct and face accountability from voters. But what we have with the Supreme Court is they're not subject to the criminal conflict of interest statute. Their disqualification statute has no enforcement mechanism or penalty at all, and we really leave it up to litigants to enforce ethical compliance only through raising objections after they've been the victims of a conflict of interest. That's not a way to promote ethics in our third branch of government.
And you discussed the ethics policy as it relates to the executive branch. Is there anything that lessons learned from the ethics policies of the executive branch that should be applicable to the Supreme Court?
Well, I think there are a number of steps that we can take. I think one positive step was the bill that was passed today, which brings the ethics regime for the federal judiciary closer to the Congressional Stock Act, which obviously has its own problems that I've previously testified about, but I think it's a step in the right direction. I would note that there are bills that would extend the criminal conflict of interest statute to apply to the federal judiciary. I think that would be a positive step, and I think banning federal judges, their families, and dependent children from owning and buying individual stocks is an easy and clear way to address financial conflicts.
Mr. Sherman, to follow up, what does it say about the Supreme Court that it refuses to adopt an ethics code for itself?
I'm sorry. Was it two?
I'll take it. I think it says to the American public that the Supreme Court and the justices of the Supreme Court are above and not subject to any standards. I mean, we just had a scandal of 131 judges that violated their legal and ethical obligations, some of whom said they didn't even know what they were, and the Chief Justice took a pass on reform. That's unacceptable.
All right, I really appreciate those outstanding answers. So obviously, I'm supportive of moving forward with a code of ethics for the Supreme Court, and with that, I yield back.
Gentleman yields back. The gentleman from Ohio, Mr. Shabbat, is now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for being here today. Mr. Chairman, the American people are frustrated. They're aggravated. They're tired. From the pandemic to the supply chain debacle, from the botched withdrawal from Afghanistan to utter chaos at our southern border, from record high gas prices to 41-year high inflation rate that we're seeing right now that's driving up the cost of virtually everything that the average person nowadays has to buy. They've had to weather crisis after crisis. After all they've endured, they just want to see their elected officials show some common sense, maybe some compassion, and implement policies that will help them and their families to make ends meet. That's what they'd really like to see us dealing with. Instead, they get yet another hearing designed to distract them from the Biden administration's policies that have failed them utterly again and again. Today, they're supposed to believe that a respected Supreme Court justice who has served on the highest court in the land, with distinction, I would add, for over 3 decades now, is suddenly unable to make his own decisions regarding the law without consulting his wife. The whole premise of this hearing is absurd on its face. However, what appears to be an absurdity at first glance takes a much more insidious turn when placed in context of recent attempts by the Democrats to smear Republican-nominated Supreme Court justices. We're about 1.5 years removed from the effort in the Senate to convince the American people that Justice Amy Coney Barrett, for example, who had a long and distinguished career as a lawyer and as a scholar, and yes, as a judge, would somehow be subservient to her husband when it came to matters of the law. Most reasonable Americans thought that was absurd as well. However, as the old saying goes, fool me once. It now appears that my colleagues on the other side of the aisle have a problem with strong, assertive women when those women don't agree with them. Instead of engaging those women in a debate on the issues, they've decided it's better to attack their motives and, of all things, question their independence from their husbands. I can't believe that I have to say it out loud in this day and age, but intelligent, accomplished women who are allowed to have their own thoughts and opinions independent of their husbands, that's the way it ought to be, and that's the way it is all over the country. The fact that we are even discussing this topic is frankly beneath the dignity of this committee. And I've been on the Judiciary Committee now for 26 years. It's 2022, for crying out loud. It's not 1952. But Mr. Chairman, the American people aren't stupid. They see this charade for what it is. It's really about abortion when it comes to our Supreme Court justices nowadays, at least the way the left looks at these things. A couple of weeks ago, when we all learned that Justice Ketanji Brown Jackson had represented numerous pro-abortion groups over the years, there wasn't a peep, not one from the other side about her recusing herself from abortion cases before the court. Didn't hear anything from the left. However, because Justice Thomas and Justice Barrett do not embrace abortion on demand, they must endure all sorts of attacks and vitriol from the radical left, including apparently this bizarre accusation that they are incapable of thinking for themselves, independent of their spouses. It's frankly an insulting line of attack, and I'm deeply disturbed it's being entertained here today. As for my questions, Mr. Paoletta, let me ask you, what do you think about the idea being floated by Democrats that a Supreme Court justice should recuse his or herself from a case based upon their spouse's opinion on that issue? And I know you've already commented on that here today, but not everybody has asked you that question yet. So let me ask you to take whatever time you would like on that.
Thank you, Congressman. I think it's absolutely inappropriate, particularly at the Supreme Court level, where the justices have a duty to sit if one of them recuses because of convenience or because of, they want to sort of have an extra safe line. It damages the court, as every single justice, I think, has commented over the years, from Justice Ginsburg to the recusal statement that the justices issued in 1993. People have their own, couples have their own professional careers. My wife's a partner at a law firm. We've been working our whole life. She's got her job, I got my job. And and I can decide, I can do, if I were a judge, and there's hundreds, that's the thing, there are hundreds of people, judges at the state, local, and federal level who have spouses who have a separate professional career, who are in the public square. I mentioned Ed Rendell. Ed Rendell was the mayor of Philadelphia, the governor of Pennsylvania, and the chairman of the Democrat National Committee. And his wife was a judge. I think that's great. I don't have any problem, and I want to make sure I understand. Justice Ginsburg not recusing is fine with me with respect to her husband at the law firm, because he wasn't making money and he wasn't involved. I'm just using it as an example of a double standard. But no, I don't think a spouse having her own views and commenting on things in the public square that come before the court is any basis at all for a justice in particular to recuse from a case.
Thank you, Mr. Chairman. My time's expired. Yield back.
Gentleman from Tennessee, Mr. Cohen, is now recognized for 5 minutes.
Thank you. Mr. Chair, I'd like to ask you a question first. My friend, Mr. Johnson, said that all of a sudden the Democrats are having this hearing because they want to beat up on Clarence Thomas. When did you first introduce this bill?
First introduced this bill in the 116th Congress 2 years ago.
That was quite a bit before all this controversy about Justice Thomas and his wife, right?
Yes, it was, and actually, I took this bill up from the late Louise Slaughter, representative from New York, who first introduced the legislation in the year 2013. I thought it was an important piece of legislation then, and I think it's even more important now.
It is, and you got ahead of me on this one.
Well, sometimes
Good
you have
work.
seniority over me because of your initials, so that it feels good.
Thank you, sir. Mr. Roth, let me ask you a question. Take me back a bit. Mr. Thomas, Justice Thomas, was first put on the court in 1991. Is that correct?
Correct.
When was the first time he ever spoke in the Supreme Court and asked a question?
I know that he was famous for not asking questions during oral argument because he did not find it a valuable exercise for him to take that time. But I remember being in the courtroom on a leap day when he asked a question. So that would have been February 29th, 2016. And I think he asked questions in 08 or 09. But it wasn't a common occurrence until the seriatim questions were implemented in 2020.
So it was a long time. And when did Justice Scalia die?
February 13th, 2016.
He started talking more after Justice Scalia died, maybe?
Well, I think the question he asked when I was in the courtroom definitely echoed something that Justice Scalia would have asked. It was about domestic violence and guns, and it had some echo there, which I thought was a nice homage to the late justice. But a few years later, because of the pandemic, we're doing live audio, and every justice gets to ask a question, and Clarence Thomas has decided to participate in that, and he's asked a question at pretty much every hearing since May 2020.
Most every justice does ask questions, do they not?
Correct.
Has there ever been anybody, other than the movie Silent Bob, has there ever been a justice like Clarence Thomas?
It's the hot bench of the Supreme Court where there's this back and forth of the justices, that dates back to 50 or 60 years ago. I really don't know what happened before that. I don't have a good sense.
Okay, thank you, sir. It just astonished me, Mr. Paoletta. I heard you say something to the effect, I think what your written testimony says, now 30 years later, Thompson is still standing strong, considered by many to be our greatest justice. Who are the many?
I'll get you a number of Tom Goldstein.
Tom who?
Tom Goldstein, a practitioner before, it said Justice Thomas is considered our greatest justice for bringing new ideas into the court. I find it, so let me just ask you a question, Congressman. Do you think that his not asking questions?
Wait a minute, sir. I've got, many is plural. Tom Goldstein's not a triplet.
I've spoken with many practitioners who say he's our greatest justice. So I can give you a list.
Give me a list, I'm ready.
Would the gentleman yield? I would be glad to add my name to that list whenever it's delivered.
I join.
Thank you. I was giving y'all are given. The fact is, this doesn't have to do with Clarence Thomas. It doesn't have to do with Ms. Ginsburg. It has to do with ethics. And I think everybody should agree the Supreme Court, which is the most powerful institution in our government, should have ethical guidelines. And if they have conflicts, they should recuse themselves or they should disclose them. And there have been instances shown where justices have had conflicts and they haven't recused and they haven't disclosed. Now, most of what we talked about, Justice Ginsburg and this Ninth Circuit gentleman whose wife was on the ACLU, nobody got paid any money. But regardless of all that, if there are conflicts, they should disclose them, and there should be such laws. Justice Scalia came before when I was chairman of this subcommittee and talked to us, and he was big on OIRA, and it couldn't be a nicer witness we ever had. Scalia was a gentleman and a scholar, and he taught us a lot, and he cared about OIRA, and he cared about the court. He came with Breyer, and the two got along great. Breyer could have been Ginsburg. I mean, they were just all buddy-buddy and wonderful.
Will the gentleman yield?
Who was it that asked? Sure, you go ahead.
I would also just make the observation that there's been a conservative majority on the Supreme Court since approximately 1972, when Nixon got 4 appointments. So the idea that somehow we are all of a sudden raising issues of ethics because there is a conservative majority on the Supreme Court is plainly belied by the facts. And I think we should dispense with making those representations moving forward if we want to be held favorably in the eyes of people who want to judge all of the information in a neutral fashion.
Thank you. I'll close, but the bottom line is we ought to have ethics, and I don't care what anybody did wrong. That doesn't make what somebody else did right, and it doesn't change the fact the Supreme Court ought to be honest and disclose it. And I'm a big fan of Justice Roberts, too.
Gentleman from Wisconsin, Mr. Fitzgerald, is recognized for 5 minutes.
Thank you, Mr. Chair. In March of 2020, Senator Schumer declared, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions." This was just before the court was about to hear a major abortion case. These comments, I think, reflect the significant escalation in some type of threat. I think many of us were puzzled even by what he was saying in front of that group on the steps of the Supreme Court. And then later on, Senator Whitehouse talked about packing the court in response to not making specific types of judgments and decisions. My point is, in bringing that up, is that there's always a political component. Certainly because you have Senate confirmation, and that process, which couldn't get any uglier than what we saw with Justice Kavanaugh. But the one thing I would like to ask about, and Mr. Paoletta, you can comment, please. There's ethics and recusal, and then there's also what I would call a code of conduct. And, we talked earlier about the standard that members of Congress are held to, but there's also disclosure and just reporting kind of what a justice might be involved in on a day-to-day basis. So, I think there's a little bit of confusion. I think the nuances are, they're there. But, I don't know that anybody is asking for politics to be removed, because I don't think you can do it, quite honestly. I just don't think it's going to happen. So, is there any lesser standard or anything that could kind of be utilized to make the point that, listen, these are wonderful people that are on the Supreme Court, and they're living their lives, and there should be some leeway in what's granted to them, and they should not be harassed by the political class. They should not be harassed by electeds, and they should be treated differently. I know in the Wisconsin Supreme Court, 10-year terms, everyone runs for office. There's different standards that need to be viewed, and I'm just wondering if you had comments on that thought in general.
Well, look, I think that the recusal statute applies to the Supreme Court. So in terms of recusals, it's in my view, it's there already. The Code of Conduct is a guidance document. And I guess even within the context of a code of ethics and listening to some of the panelists, their view is showing up before the Federal Society and not streaming your speech is some sort of ethical violation, and I just fundamentally disagree with that. I look at the Code of Ethics as it exists. It says a judge may engage in extrajudicial activities, including law-related pursuits and civic, charitable, educational, religious, social, financial, fiduciary, and governmental activities, and may speak, write, and lecture, and teach on both law-related and non-legal subjects. And the Federal Society is a 501c3 educational group. No matter how anyone wants to describe it, that's what it is. And it's been an incredibly good force in the United States in terms of the development of the legal system. Now, there's the ACE, the American Constitution Society, ACS. It's great that justices go and speak there. It's not, I'm looking at Mr. Stewart's testimony. It says, concerns about undue influence are further magnified when organization is viewed as having close ties to an extraordinary influence over several members of the Supreme Court, including by getting them to accept legal arguments that were previously outside the mainstream. Again, these are incredibly accomplished justices that this thing is saying, this statement is saying, somehow they are in the throes of this organization. And in terms of the law students who have grown up in this great organization and engaged on the law, and if you've ever been to a federal society, they have lots of liberals there, they have lots of libertarians, and they have lots of conservatives. It's a great debating society. I've never been to an American Constitutional Society. I think it's probably the same, but those are great organizations. And under the Code of Conduct, as I read it, and you gentlemen could disagree with me, you would be allowed to do that. You would be allowed to but it's every time these representations are made about the justices speaking at the Federal Society, it's somehow bad. It's good, and it's permitted by the Code of Ethics. If it were, you know, again, I think the justices consult the Code of Ethics, and they're living their lives and engaging in the legal community in a good way.
Thank you. I yield back.
The gentleman from California is recognized for 5 minutes.
Thank you, and I thank the chairman for hosting this important and certainly timely hearing. And I want to start with Mr. Sherman. Mr. Sherman, as Congress considers what legislation is appropriate in the area of judicial ethics and recusal, I think it'd be valuable to look at the various standards that we might apply to government officials and the interests those standards promote. It seems to me that in easy cases, an action might be clearly unlawful because it violates the plain text of the law. For example, when Mr. Paoletta, the gentleman seated to your right, was the general counsel of the Office of Management and Budget under President Trump, he asserted that that office could bar the Defense Department from providing $214 million that Congress clearly appropriated to help Ukraine defend itself against Russia. That would have been really helpful for them to have that money. But the Government Accountability Office concluded that Mr. Paoletta and his office clearly violated a federal statute called the Impoundment Control Act, and that Mr. Paoletta's assertions had, quote, no basis in law. I'd like to enter that GAO report into the record. In the most serious cases, the standard might hinge on what someone knew or their state of mind. For example, a person in Mr. Paoletta's position would be in jeopardy if that person had known that he was holding up the security assistance to Ukraine because President Trump thought it would help him get dirt on Mr. Biden, his political opponent. And it would be even worse if a person in Mr. Paoletta's position, despite his obligations as a government official, had specifically intended to help the president use public money for the president's own private gain. This is precisely the point of an ethics rule to deal with issues of impropriety. It would also account for other situations, like here, where Mr. Paoletta was responsible for responding to the public and congressional inquiries about his own involvement in illegally holding up aid to Ukraine because President Trump thought it would help his re-election chances. So when Mr. Paoletta faced calls to recuse himself because of a conflict of interest, Mr. Paoletta refused. And now there will always be questions about why Mr. Paoletta failed to give GAO the information it requested or why, according to some sources. His answers conflicted with the blacked out portions of documents whose redactions he reviewed. I'd like to enter into the record a letter from Senator Chris Van Hollen asking Mr. Paoletta to recuse himself from that matter. So, Mr. Sherman, I appreciate you bearing with me on this, and my question is this. Clearly, appearances matter when it comes to government ethics, but there are also other interests at play. Would you agree?
Absolutely. I think particularly with the Supreme Court, appearance matters a great deal. Again, their authority and function derives from their impartiality. And if there are issues that would lead a reasonable person to believe that justices aren't impartial, that undermines the entire rule of law and the entire judicial system.
And what are the classes of cases where Congress should consider holding judges accountable for egregious ethics violations?
Well, obviously there is impeachment, and and that's in the Constitution, and there's a process for that. But frankly, short of impeachment, there's not a lot of mechanisms existing for Congress or for any branch of government to hold members of the Supreme Court accountable for anything. And we've seen that through rampant abuses that Mr. Roth and Mr. Paoletta have identified, that there are no checks on the Supreme Court's ethics, and that's why we need a code of conduct to hold them accountable.
However, Mr. Sherman, lower court judges can be disciplined or disqualified from certain cases when acting unfairly without avoiding impropriety, engaging in political discourse, or not acting with the utmost integrity. So there is a precedent for doing this with judges. So can you explain how consequences are doled out to judges in the lower courts who do not adhere to the code of conduct?
Well, I think there's a couple of different mechanisms. One is the process of appeal. If a judge doesn't appropriately recuse themselves, that's an option for litigants. But there's also a process that goes through the judicial conference where there is an underlying investigation, and members of the bench are recommended for disciplinary action if there are violations.
Great. And Chairman, I just want to note also that I have not gotten onto some of the legislation around this issue that you are working on, or signed on to some of the letters that you have issued that you've worked on this, and that's simply because I, in my personal capacity, have a case that I do believe will be in front of the Supreme Court, or that it's a high likeliness that it will be in front of the Supreme Court, and I think it would be inappropriate for me to use my legislative office to advance any issue or anything that could affect how the court recuses or does not recuse. So don't read into it one way or the other, but I just want to put that on the record.
I thank the gentleman.
Mr. Chairman, since the last questioning round clearly impugned the witness, I'd like to have him at least have a minute to respond if you'd like.
I'll give the witness 30 seconds to respond.
30 seconds, okay. I stand by that opinion. We had complete legal authority to pause that money for 60 days. I'll point out that if this was after the Obama administration refused to provide Stinger missiles to the Ukrainian people, it was a review that was signed off on up and down the chain in my office. You mentioned the, GAO has disagreed with executive branch actions over the years, including finding that President Obama broke the law in exchanging the traitor Bo Bergdahl for prisoners, and he broke the law in that exchange. So GAO has their opinion. They're Congress. They're not independent. Okay, so the executive branch has its own legal opinions. OLC is the binding authority for OLC. They didn't disagree with my opinion, so I stand by that 100%.
The gentlelady from Minnesota, Ms. Fischbach.
No.
Excuse me, I'm sorry.
Thank you, Mike.
The gentleman from North Carolina, Mr. Bishop, is recognized.
Thank you, Mr. Chairman. I wasn't sure my mic light's not coming on, so I think it's on, though. You can hear me, right? Mr. Paoletta, I wasn't here for your oral testimony. I read your testimony, and I thought at the end you had something here that it was worth noting and then commenting on. You said, but the trigger for this new proposed legislation is a ginned-up smear attack on Justice Thomas and his wife. And Mr. Cohen of Tennessee suggested that the legislation's been out there longer. I'd suggest swapping the word hearing for legislation. I think the salient issue is the timing of this hearing. But I do think that what you said is apt. This is a ginned-up smear attack on Justice Thomas. And it brought to my mind the fact that I don't think things have changed so much in the 31 years that have passed since this event. In the photo behind me, there you go. The progenitor of the process of borking Supreme Court nominees, the Honorable Edward Kennedy. You got Senator Strom Thurmond, close friend and collaborator with the big guy in the middle. And on that occasion, the core language that Justice Thomas used, if you'll recall, at the end of his statement was, from my standpoint as a black American, as far as I'm concerned, it is a high-tech lynching for uppity blacks who in any way deign to think for themselves, to do for themselves, to have different ideas. And it is a message that unless you kowtow to an old order, this is what will happen to you. You will be lynched, destroyed, caricatured by a committee of the U.S. Senate rather than hung from a tree. How little things have changed. Wouldn't you say that this hearing and its focus on Justice Thomas, the demeaning way in which Justice Thomas is distinguished from other jurists that have been pointed out in your paper and the comments that have been made about them, the notion that Justice Thomas is dependent on his wife, has much changed at all since that hearing, since the comments from Justice Thomas 31 years ago?
No, and I'm actually kind of shocked by Congressman Cohen's questions. I'm not sure what he was driving at, that Justice Thomas didn't ask a lot of questions. I do think he asked more earlier in his career, but if you go back over the years with various justices, they didn't ask a lot of questions, but I'm a little concerned by what Congressman Cohen was trying to imply there.
So the salient issue, again, seems not to be the timing of the legislation, it's the timing of the hearing. It's just like the well-timed warning outside the Supreme Court building, you won't know what hit you, right? That's what we're dealing with. That's what we're still dealing with today. And I think it's just worth noting how much this country has depended on the fortitude of Justice Thomas to withstand this kind of unseemly treatment for all those 31 years, and what a debt of gratitude the country owes to him. And with that, I'll yield back.
Gentleman from New York, Mr. Jones is recognized.
Thank you, Mr. Chairman, for holding this hearing and for introducing the 21st Century Courts Act, which I'm very proud to co-lead with you and so many others on this committee. I am so glad we are finally having this hearing because the American people need to understand what the hell is going on with this far-right Republican majority on the Supreme Court of the United States. Contrary to the claims made by my Republican colleagues today, who, by the way, would have impeached Justice Thomas by now if he were a liberal justice, there is nothing normal about what is happening at the Supreme Court of the United States. We have a Republican majority on the Supreme Court that is more corrupt than ever before. And none of those Republican justices is more corrupt than Justice Clarence Thomas. Make no mistake about that. In the early 2000s, he repeatedly declined to report hundreds of thousands of dollars that right-wing organizations paid his wife, Jenny Thomas. Then Justice Thomas voted to advance the radical agenda of his spouse's far-right employers with impunity. And now it has come to light that Justice Thomas ruled on cases concerning the 2020 presidential election and the insurrection right here at the Capitol, even though his wife was conspiring with the White House to overturn President Biden's victory by any means necessary. So contrary to the claims made by the ranking member earlier today, no wonder public approval of the Supreme Court is at the lowest level it has ever been. It's not just the Republican Party's, the Republican majority's decision to take away fundamental rights, like the right to an abortion. It's not just the Republican majority's decision to take away fundamental rights, like the right to vote in this country. It's not just the Republican majority's decision to undermine your right to join a union in this country. It's not just the Republican majority's clear intention to make it more difficult for our government to prevent gun violence this term, but it's also the blatant corruption at the Supreme Court of the United States. So I would submit to everyone that enough is enough. In the United States of America, no one should be above the law, not even Supreme Court justices. Mr. Sherman, let me ask you some yes or no questions to piece together what we've heard today. Federal law requires that, quote, any justice of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned, correct?
Yes.
Now, do you think it might be reasonable to question whether Justice Thomas, the spouse of someone who repeatedly urged the White House to overturn that free and fair 2020 election, could impartially participate in proceedings about the, wait for it, attempt to overturn the 2020 election, proceedings that may well reveal evidence of his spouse's high-level role in a criminal conspiracy?
Yes, absolutely.
Yet in Trump v. Thompson, Justice Thomas was the only justice who voted to deny the January 6th Select Committee access to White House records about the insurrection that might have included Jenny Thomas's text messages with Donald Trump's former chief of staff, Mark Meadows. And of course, he was the chief of staff at the time. So what Justice Thomas did was not just unethical. It was illegal. It was in violation of the recusal statute. There's no doubt about that, not among people of good conscience and sound intelligence. Yet, as you have testified, nobody could compel Justice Thomas to recuse because the statute lets each justice decide for themselves, correct?
Yes.
So the only person who decided that Clarence Thomas didn't need to recuse himself from cases concerning the insurrection was Clarence Thomas himself, correct?
Correct.
How could that possibly be consistent with the bedrock legal principle that no one should be the judge in their own case?
It's not, and it's not even consistent with Clarence Thomas's prior recusal practices, but there's no standard, so we'll never know.
How would the 21st Century Courts Act change that?
Well, I think it would do a number of things, including allowing for transparency in the recusal process, extending the criminal conflicts of interest statute to the federal judiciary, which would put some skin in the game for the justices, and obviously require them to create a code of conduct, which has been sorely lacking and obviously is desperately needed.
And you stand by your claim, as has been articulated by scholars throughout the legal academy, that Congress is well within its authority in enacting legislation that would, among other things, implement a binding code of ethics on the Supreme Court justices.
I do, and I believe that if the court were to challenge that, it would further undermine their credibility in a very dangerous way.
You won't have any argument from me on that. I yield back.
The gentleman from Wisconsin, Mr. Tiffany, is now recognized for 5 minutes.
Thank you, Mr. Chairman. I yield my time to the ranking member, Mr. Issa.
Thank you. I thank the gentleman for yielding. I want to pick up where things were left off a little bit. There was an earlier set of questions about Justice Thomas's not asking questions. I'm trying to understand something about Justice Thomas because I've known him for a long time. He's been a figure in Washington for civil rights before he was a justice on the Supreme Court. Let me go through a couple of these things. Is it that he is too strident, strong-willed, and unmovable as a justice that he never listens? Is that why he doesn't ask questions?
No, I think that's the exact opposite. And I think he has said that the gotcha type questions is kind of more of showmanship on the court where the various justices are, kind of arguing amongst themselves, not really, and using the litigants as a cutout to ask the question. So no, I think Justice Thomas listens to questions. And again, when you look at his jurisprudence, it's as independent as any justice up there. So,
Well, let me go to the opposite side then. Is he so pliable and without a core set of values that he could be easily influenced by somebody close to him?
That's absolutely not. That's anathema to Justice Thomas's entire life.
No, I've seen, 18 or 20 or maybe a little more justices go through confirmation process in my life, and a chunk of that during my service in 22 years. Can you name any justice on the Supreme Court now or in the recent past who lacks both a broad history of thinking and decision-making sufficient to have high confidence that they make their own decisions. Can you think of even one justice that you would say lacked that ability?
No.
Then why is it that Justice Thomas seems to be the one that's being questioned here for one of those two, either too strident or too Gumby-like, and not at all the level of intellect that every other justice seems to be given as a granted by everyone on this panel, as far as I can tell?
I think it's why. I think there's a racism that is directed at Justice Thomas. If I can just read from a book from 1995, which was called Strange Justice by Jane Mayer and Jill Abramson. They said when Thomas got on the court, he developed an unusually close friendship with, some would say reliance, on his fellow jurist Lawrence Silberman. Thomas served on the court. He was generally quiet during oral argument, according to clerks, and in a departure from normal practice, the administration took an active role in helping Thomas pick his clerks. Most were carefully culled from the best law schools, and many of them were Federal Society alums. The draft opinions needed a little embellishment, according to the clerks from other chambers. Thomas leaned especially heavy on them. Okay? Thomas, several clerks from other chambers remember Thomas as a slow writer. This is just pure racism. Okay?
So
that's what this is.
What you're seeing is decades of attacks on Justice Thomas because he's black.
And conservative, yes.
And conservative, a bad combination.
Yes.
Let me go.
Might I offer a response?
In just a second. One follow-up. We on this committee have in the past offered and gone through with articles of impeachment for judges for their conduct. And we do so based on not the same standard as the executive branch. We do so based on that provision that includes good behavior, correct? Now, if without a written set of documents saying this is what a judge must do, or with one, in either case, wouldn't the removal of a justice from the high court be based, one, on impeachment as the only tool to remove him, and two, based on our belief that they had violated high crimes, misdemeanors, or the quote, good behavior?
Correct.
So even though it might be helpful for Congress to have a set of standards, and even though we could label that set of standards over them, at the end of the day, isn't the standard for removal of a justice exactly the same?
Yes.
Thank you. I thank the gentleman. Yield back.
Votes have been called about 30 minutes ago, and there are still a few voters who have not voted yet.
And we are among them.
We are among them. So we must depart at this time. We will return in about 55 to 60 minutes. And if you all will hang loose until then, we'd greatly appreciate it. With that, we will recess. Yeah, we will resume this hearing, and I have waited for some minutes now, maybe 5 to 7, for any of my colleagues to reappear. And none having done so, I'm left. Oh, Miss Ross, okay. All right, so we do have a colleague, Representative Ross. I will yield to you 5 minutes
Mr. Chairman, I
for
believe you're
questions.
on mute. We can't hear you.
You cannot hear me? Okay. Testing, testing. Okay. Okay, can you hear me now? Testing, testing. Representative Ross, can you hear me? I don't think you can. We'll recess for just a couple of moments to work out this technical glitch. Ms. Ross, can you hear me? I don't think so. You did not hear me, Ms. Ross? Can you hear me now? All right. Okay, we are now back into session. Call this committee meeting back to order. First, let me apologize to the witnesses. I told you when we left at about 4:15 that it would be about 55 minutes to an hour, and it ended up being about 2 hours. For that, I deeply apologize. I know you're busy and have things to do, so we appreciate you sticking around. There is one additional member who has come back to offer questions to you. It's Representative Ross. And before I go to her, I just wanted to congratulate her on today's Senate passage of her legislation, hers and Representative Issa's legislation, the Courthouse Ethics and Transparency Act, which will proceed to President Biden for his signature. Congratulations to you, Representative Ross. And you may begin with 5 minutes of questions.
Well, thank you, Mr. Chairman, and thank you for your leadership and for being a co-sponsor of the bill along with Mr. Roy. And I want to thank the panelists for joining us today and for your patience. I hope somebody else comes to ask the question or my questions are worth your time. But I value your suggestions and insights into how we can improve the integrity of the Supreme Court. It is only appropriate that the highest court in our judicial system be held to the highest ethical standards. And let's remember, as you have all said, these are lifetime appointments. So there is no check on what they do other than the extreme action of impeachment. But for years, we've seen the Supreme Court justices avoid recusals, and this compromises their ability to interpret the law impartially and without influence. I'm grateful of the work that this committee has done, especially with the Courthouse Ethics Act that the chairman talked about. And I'm grateful that that was both bipartisan and bicameral. It's an important first step toward an impartial judiciary through the creation of financial transparency requirements for federal judges. But we must do much more to ensure that the Supreme Court operates in a way that shows no favor and is free from external influences that place unbiased interpretation on the law into question. This means putting the mechanisms in place to guarantee that justices recuse themselves properly from cases and are held accountable when they do not, and avoid conflicts in the first place. I hope that Congress will move forward and establish a Supreme Court code of ethics if the justices themselves are unwilling to do so. Of course, that would be the first choice. So what I would like to do is I have two questions very quickly, Mr. Roth, because I'd like to get to my second question. We talked about the courthouse ethics bill. Do you believe it'll succeed in getting judges and justices to be more aware and mindful of potential conflicts? And if you could be brief, that would be great, so I could do my second.
Sure, yes, absolutely. I think that there's a lot of embarrassment that followed the Wall Street Journal story and the fact that your bill carried through. I think they're already changing their habits, and we'll see some divestments in the coming years, and I think it'll be a big step in the right direction towards financial accountability.
Thank you so much. And Mr. Gillers, you said in your testimony, I have long defended the right of judicial spouses, including Ms. Thomas specifically, to join public debates on issues that could come before their husbands or wives without affecting the ability to sit on cases. Attention to detail rather than superficial similarities reveals that this time the Thomases went too far. You've said that the revelation that Ginny Thomas actively communicated with Mark Meadows regarding the results of the 2020 election was a game changer. Could you explain this to us and what distinguishes that activity from freedom of speech?
about 12 or 15 years ago, I began to get questions from the press about Virginia Thomas's activism and the effect, if any, on her husband's ability to sit. And I always said they live in different spheres, and we do not impute ideology between spouses. We impute financial interests, but not ideology. Oftentimes, the reporter was incredulous, but that was and is my position. It may not always help with public confidence in the judiciary, but each has a right to his or her own professional life. When I was called by the New Yorker in January, I maintained that position. And if you read the article again, you'll see that although I wasn't happy with, and am not happy with the extent of Virginia Thomas's activism, because I believe it hurts the court, but she has a right to do it, and if she wants to do it, that's her prerogative. So I did not say, and would not say, and the article does not go so far as to say—
What about the issue of the communications with Mr. Meadows?
So then what happened is in March, the Meadows texts appeared. And the game changer was Virginia Thomas was now not merely voicing her opinion, but she joined the Stop the Steal effort with the strategy, ultimately, as it turned out to be true, to go to the Supreme Court, to go to her husband on the court and the rest of the court. And so when she shifted from voicing her views publicly, fine, to becoming an insider, a player in the Stop the Steal effort by going to the senior partner, if I may, of that effort, Mark Meadows, with 21 texts in 1 month, and we'll may find out that there's even more thereafter. When she did that, she had an interest in the cases in the Supreme Court as an insider, and because she has an interest in not seeing future disclosures of what she may consider private communications about ways to stop the results of the election. That changed it for me after all those years.
Well, thank you very much, Mr. Chairman. Thank you for your indulgence, and I yield back.
Thank you. Mr. Paoletta, I'd ask if you'd have any response to that.
Ginny Thomas expressed her concerns about the election to Mark Meadows, her longtime friend. When you see other, again, it's in the context of, so I don't think she's on any team. I think she was expressing her views, just like Judge Reinhardt's wife filed a brief, actually tried to intervene, talked to the lawyers before, so I would assume that's kind of behind the scenes of arguing that case on Proposition 8 on the same-sex marriage issue. So I don't see any difference between the Reinhardt case. I know Professor Gillers is trying to make that distinction, but I don't see any distinction there. She sent some text.
Assuming that there is no distinction, doesn't it still call into question whether or not there's a need for a code of ethics?
Well, again, my view is that Reinhardt was proper in not recusing, just like Justice Thomas was proper in not recusing. So that's my view.
When should a justice recuse?
When, in my view, it's when your spouse or family member has.
So in accordance with the statute?
In accordance with the statute, you're a party to the case. You're a litigant right before the case. As Professor Gillers points out in his opinion on the Reinhardt thing, Ms. Ripson was not a party or a lawyer before the court, and that's the key. And she didn't have a financial interest. Thomas has no financial interest in there. Just like he says, the interest that she has is she cares about election fraud. Just like the interest that Ramona Ripson had was on Proposition 8 and stopping the same-sex marriage ban. So to me, there's no distinction between the two. And in fact, I'd say that Ginny Thomas was further away. I mean, Ramona Ripson ran the ACLU organization, and she was involved with getting briefs put together. maybe minimally, I didn't do my own investigation, but at least her own husband says that she was involved with the beginnings of it. They actually filed a brief, 2 briefs, in the court below. That's taking a position on a case that's now before her husband. So I'll give the other one that I've talked about a lot,
But
which is Judge.
it still did not require Reinhardt to recuse in that circumstance. What is your opinion about that, Professor Gillers?
There are very important differences between the Reinhardt situation.
Your microphone.
There are 2 very important differences between the Reinhardt situation and the Thomases. Ramona Ripston had no worry that the decision of the Reinhardt court would reveal confidential information that she exchanged in private, in texts. There was no threat to Ramona Ripston of that, number one. Number two, Ripston and the CLU were not before her husband. They did not file an amicus brief in the Ninth Circuit. However, the case before Judge Thomas had the team that Mrs. Thomas joined before him.
Again, when you talk about team, what does team mean?
All right, so we won't get into a tit for tat between witnesses. But I'll let you conclude, and then I'll go to Congressman Jordan.
Mrs. Thomas could have done a number of things after the election was called. She could have talked to her friends. She could have gone to social media. She could have gone to the blogosphere. She could have written an op-ed. But where did she go? She went to the man who would predictably run the operation.
Party to the litigation, essentially.
Sorry?
A party to the litigation.
Yes, she became part of the litigation. And that litigation would predictably get up to the Supreme Court, which it did, and her husband.
Okay, thank you. Representative Jordan, you're recognized.
Thank you, Mr. Chairman. I'd ask unanimous consent to first enter into the record a paper by Thomas Jipping, Senior Legal Fellow at the Edward Meese Center for Legal and Judicial Studies at the Heritage Foundation on the subject of the hearing today.
Without objection.
Mr. Paoletta, does it matter whether a Supreme Court justice asks questions or doesn't ask questions? Is that an ethical concern?
No, sir.
Yeah, I mean, Mr. Thomas, if he chooses to ask questions, God bless him. If he chooses not to, God bless him. He's a member of the Supreme Court. He can conduct himself as he wants and get to the decisions that he wants to get to. But that was raised earlier, I think, by one of our colleagues on the court. Well, why do you think they would raise that?
To disparage Justice Thomas.
To keep doing what they started, what, 30 years ago?
Yeah.
Isn't this really, in your mind, Mr. Paoletta, this is about the left continually coming after people who, conservative jurists who are being put on the Supreme Court. I mean, you can just go down the list and the treatment that it started with Justice, well, it started with Bork, we talked about that, but it started with Justice Thomas. But we saw it, I think I remember, was it Justice Alito's wife who was in the row behind him, I think, and moved to tears based on what they were doing to Justice Alito?
Yeah, I think they accused him of being a racist.
Yeah. And then, of course, we saw what they
falsely accused him of.
Falsely accused. We saw what they did to Judge Kavanaugh. We saw what they did to Ms. Coney Barrett. And now, Justice Thomas, they're coming at him a second round. This is all about the left's desire, I think, and I said this in my opening statement, to pack the court. Would you agree?
Yes, and I'd say they've been coming after him multiple times over the years. I think 2011 was the one with Obamacare. He needed to be impeached because Ginny Thomas deigned to have an opinion and express it that it was a disaster, and Justice Thomas didn't recuse. I think Professor Gillers agrees with me on that. These two gentlemen, I think, probably disagree with me that Justice Thomas should recuse. I think it's quite clear he shouldn't recuse.
Yeah. But what do you think their ultimate motivation is? The left's continual attacks. I mean, just attacks that are so far out of the norm. I mean, just again, what happened to Judge Alito? What happened to Judge Thomas? What happened to Judge Kavanaugh? Why are they so focused on this?
Number one, I think right now, I think they think the court is going to be issuing a number of rulings that are going to wipe away a number of liberal, longstanding precedents. Mm-hmm. I think it's and to disparage the court, and that's why I think that the poll numbers are down. One follows the other, okay? And so now they get to say, the poll numbers are down, we need to do something with the court. I also think it's to send a message to a lot of the other conservative justices that nobody likes to be disparaged and caricatured and destroyed. It's not fun. And you need to have an iron backbone like Justice Thomas does, in my opinion. So they know they'll never bend him. I'm certain of that, and I'm certain that his opponents do that. They want to try to marginalize him, and they have failed at that utterly, in my view. But I think it's to send a message to the newer justices that are up there.
That is always the goal. When the left comes after people, when they try to disparage people, when they put them in what Barry Weiss described when she resigned from and Barry Weiss wasn't on the right, she was on the left. But she resigned from the New York Times, said because she couldn't offer an opinion that differed from the woke mob. She says, because if you go against the groupthink, if you go and you engage in wrong speech or wrong think, as she described it, you will face the digital Thunderdome. They will come after you, and it's all designed to chill speech of other individuals. The left is so... Today's left says, if you don't agree with them, you're not allowed to talk. And if you try, they're going to call you names and try to cancel you. Again, don't take my word for it. Take someone on the left, Barry Weiss's word for it. And you want to know how much they want to control speech and go after people who they disagree with? Just look at their reaction to what Elon Musk did this past week. I mean, the left controls everything. They control everything. And one platform in the social media, and all the social media platforms, one platform may now go to where they're actually fair. Oh my goodness. The left loses their mind because the guy who builds electric cars and believes in the First Amendment just bought a company. Wow. So that is what's at stake here. And that's why this is so wrong. And they come after Justice Thomas. It's in the name of ethics. It's so transparent what they're doing.
I agree with you. Justice Thomas has withstood it all, and he has been on the court for 30 years, and he now has, I think, 15 or 16 former law clerks on the federal bench, including Kat Mizell, who just issued the order striking down the Biden mandate. So his legacy is continuing on.
He's a great American and someone we should put up there as a role model for so many people, and yet the left wants to come after him, and it is wrong. So I appreciate you coming here today and defending him and defending the truth and the way our Constitution and the way our system is supposed to work. With that, Mr. Chairman, I yield back.
Thank you, Mr. Jordan. Mr. Sherman, how do you respond to the idea that it is somehow racist to express legitimate concerns about Justice Thomas's unethical conduct?
Thank you for the question. Congressman, I firmly believe that multiple things can be true at the same time. I believe that Black men in America face racism, and that Justice Thomas likely has faced racism in his past. I also think that there are a litany of ethics abuses committed by Justice Thomas that raise significant questions about his conduct in his role as a Supreme Court Justice. I think his conduct with respect to the recusals in Trump v. Thompson and other cases that implicate not just his wife's conduct, one, threaten our democracy, and two, frankly, differ from his approach to cases that have involved conflicts with his son. And I think it's reasonable to question why Justice Thomas has chosen to recuse in cases where there is a minimal conflict risk with respect to his son, which I think was appropriate, but not chosen to recuse in a case where it's not just his wife's views, but it's that her conduct is implicated in the documents that were at issue. The White House was talking about a Supreme Court strategy, which would have to presume include discussions about strategy with respect to Justice Thomas, and certainly could have included information about Mark Meadows' communications with Ginny Thomas. And so I think it is highly pertinent for this committee, and I think it's, quite frankly, laughable to label those legitimate concerns as racist just because Justice Thomas has faced racism in the past.
Thank you. Mr. Roth, you have described Supreme Court justices taking lavish junkets, enjoying suites of rooms reserved for them and their guests, and generally enjoying benefits for which they do not have to pay and which they often do not have to disclose to the public. Can you tell us why justices do not have to disclose these gifts?
Sure. So there is a personal hospitality exemption that the justices construe to be very broad. So it's maybe not just staying at a, when Justice Ginsburg would go to New York, she'd stay with her daughter, or Justice Breyer staying with his grandkids. It's the justices construe it to say, Justice Thomas construes it to say that, whenever he's flown on a private plane by a certain, financier who may be a friend of his, but has also donated $5 million to the Republican Party, that counts as personal hospitality, and I don't have to put it on my annual financial disclosure report. And we know that even if it's not personal hospitality, and we think it's a trip that is covered by the Ethics in Government Act, which then translates to being reported on the financial disclosure report, we know that the justices are leaving things off of them. When we've done investigations into justices' trips, we've found instances where they're in a certain place at a certain time, speaking to a certain audience, and it's not personal hospitality, and it's not on the disclosure, and we know that they've gotten those perks for free. So to me, it's just a pattern of many years of just saying, I'm too good for this, I'm above the law, maybe the Ethics in Government Act doesn't apply to me. And I think that, through the 21st Century Courts Act and other legislation, we have an opportunity to change that.
Now, you have documented, your organization has documented numerous instances of Democratic-appointed justices engaging in these activities that they don't report, and using this personal hospitality exemption to their benefit, to the detriment of the taxpayers and to the American people who deserve to know who is paying for gifts for their Supreme Court justices. You've documented democratically appointed
absolutely.
And Republican appointed.
Absolutely. And part of this is a numbers game, right? Since in my entire lifetime, and 15 years before that, there have been more Republican appointed justices than Democratic appointed justices. Right, and so it's just going to be natural that over time, it's more likely that the Republican-appointed justices are going to have more of these potential ethical failings. So it's not going after a specific justice or a specific party. I mean, I do think that some of the Justice Thomas examples are outside the mainstream of some of these instances of flouting the ethics rules. But yeah, this is something where we've seen over time both justices appointed by the left and the right have been, quote unquote, guilty of these abuses. And I think an ethics code and a recusal statute expansion would assist in ending that.
Mr. Sherman, are the types of inducements that justices receive coming from parties with business before the court or from individuals seeking to influence the court's rulings, which or both? I mean, why would anyone try to offer a free transportation, free hotel, free meals? Why would anyone do that other than either they have business that is about to come before the court or is in the bosom of the court, and they're trying to influence the court? Why else would they do this for justices? And they're doing it, by the way, claiming a tax deduction for a business expense. So the American people are paying for it, essentially. Why would any entity do that for a Supreme Court justice?
I can't assign intentions to every entity, but it seems quite clear that the general motivation is, as you said, to ingratiate themselves with members of the court, perhaps to introduce legal theories that may not be front of mind, to have an audience for their members and and folks that support their legal ideology. I think at bottom, whatever the motivations, it certainly creates an appearance problem that would lead a reasonable person to question the impartiality of justices that are going on these junkets, and frankly, that aren't disclosing them. And that's exactly why the Supreme Court needs a code of conduct.
Professor Gillers, in light of what we have heard about these junkets and these trips, all expense paid, not reported in many instances, what effect does this have on our democracy?
Well, of course, our point of reference is ordinary people and the kinds of connections they will make. And so the public will see this as giving the donor certain, however slight, but certain advantages before the recipient of the largesse. It's a cheap investment. We talk about suites and travel, but in terms of the amounts of money at stake for people who litigate commercial cases in the Supreme Court, it's a pittance. And so from the public's point of view, remember the public cannot do this. From its point of view, it looks like there's a thumb on the scale. That may not be literally true, maybe that's unfair as it turns out, but that's how it will appear, and appearances are important.
Well, thank you. I appreciate all of the witnesses for your testimony today. I would remind everyone that the hearing was entitled Building Confidence in the Supreme Court through Ethics and Recusal Reform. That was the title of our hearing. I think we have largely stood by that in terms of the substance of the hearing. And I want to thank the witnesses for their appearance today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And without objection, the hearing is adjourned.